Well, hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. If you're enjoying our legal education content, please remember to subscribe. It helps the channel grow. For today's live stream, we are doing a case that was decided today by the United States Supreme Court. It is Google versus Oracle. So Oracle over here was the owner of Java. They bought it from Sun Microsystems, who invented it. And then Google, without permission, put many lines of code from Java into the Android operating system. And so there became a lot of disputes about exactly what was going on. So the idea was it was declarative code rather than operational code. So there was an idea, is this just function calls? What's the substance of this? If they're function calls, are they copyrightable? Is this equivalent to just the words in the dictionary, or is this equivalent to also the definitions? All kinds of stuff. There was a lot of confusion, not on my part, but there was confusion about what the legal arguments exactly were. So all those mysteries will be dispelled today. We're going to learn about exactly what Google did and whether or not it's infringement and whether or not there's a copyright. We're going to learn all those things today. How exciting. So we'll decide how big a deal it is in the end. So great, let's decide that, and we're going to read the case and figure out what the hell is going on with copyright and computer code and APIs and declaration code and all the rest of it. Fun. Great. Let's read this thing. Justice Breyer delivers the opinion of the court. Oracle America is the current owner of copyright in Java SE, a computer program that uses the popular Java computing programming language. Google, without permission, has copied a portion of that program, a portion that enables the programmer to call up pre-written software that, together with computer hardware, will carry out a large number of specific tasks. The lower courts have considered whether Java's SE owner could copyright the portion that it was copied. So there's this idea about maybe it's not copyrightable at all because it's mere instructions, which, no. And if so, whether Google is copying nonetheless consisted of a fair use of that material, thereby freeing liability. The Federal Circuit held in Oracle's favor the portion that's copyrightable, that is, that the portion is copyrightable and the copy did not constitute a fair use. So, yeah, Federal Circuit over here held in favor of Oracle, which lets you know right away, because the Federal Circuit gets busted by the Supreme Court all the time, that Google's going to win this thing. The poor Federal Circuit, which is my principal circuit court of appeals. The Supreme Court loves bashing them around these days. So in reviewing that decision, we assume for argument's sake, the material is copyrightable. So we're not going to answer the question of if it's just pure instructions that doesn't qualify as copyright. But we hold that copying is nonetheless fair use and therefore overturn the Federal Circuit. Big surprise. Hence, the Google copying did not violate copyright laws. So all you guys who thought that if Oracle win, it would be the end of the internet and computer codes and stuff, you guys can rest easy, because even assuming it's copyrightable, which, they're not deciding, we'll note, even assuming it's copyrightable, which they're not going to decide for some reason, it's apparently fair use. So yay, you can continue to do what you were doing before. How fun. So let's learn a little bit about the history of how this came to be. In 2005, Google acquired Android Inc., a startup firm that hoped to become involved in smartphone software. Google sought through Android to develop software platforms for mobile devices, like smartphones. A platform provides the necessary infrastructure for computer programmers to develop new programs and applications. One might think of a software platform as a kind of factory floor where computer platforms analogous to auto workers, designers, or manufacturers might come, use a set of tools found there, and create new applications for in-use, say, smartphones. For visual explanations of platforms and otherwise some specialized material terms, you might want to look at Appendix A. We may consult Appendix A to see what platforms look like if you're really, really good. Google envisioned an Android platform that was free and open, such that software developers could use tools found there free of charge. Its idea was more and more developers using Android platform would develop ever more Android-based applications, all of which would make Google Android-based smartphones more attractive to the consumer. Consumers that would then buy and use ever more of these phones. That vision required attracting a sizable number of skilled programmers. At the time, many software developers understood and wrote programs using Java, a language invented by Sun Microsystems, Oracle's predecessors. About 6 million programmers have spent a considerable time learning and then using the Java language. Many of these programmers use Sun's own popular Java SE platform to develop new programs primarily for use in the desktop and laptop computers. That platform allowed developers using the Java language to write programs that were able to run on any desktop or laptop computer, regardless of the underlying hardware. That is, the programs were in large part interoperable. Indeed, one of Sun's slogans was "Write once, run anywhere," which was, a little bit more aspirational than true, but, whatever. Shortly after acquiring the Android firm, Google began talks with Sun about the possibility of licensing the entire Java platform. But Google did not want to insist that all programs written on Android be interoperable. As Android's founder explained, the whole idea about open source is to have very, very few restrictions on what people can do with it. Some of those restrictions include you can't use our code, apparently. And Sun's interoperability possibility would have determined that free and open business model. Apparently, for reasons related to this disagreement, Google's negotiations with Sun broke down. Google then built its own platform. So yeah, Sun Microsystems over here, which became Oracle, wanted to say basically this is like a GPL kind of thing. It's like if you build it using our terms, you have to create interoperabilities or else it's copyright infringement, right? So this is kind of the idea of the GNU public license or any of those copyleft licenses. It's like by using our things, you have to work under our rules. So Google over here didn't want to be in the copyleft universe. They didn't want to be in the GPL kind of universe. They wanted to use the copyrighted code and not have to be subject to that sort of scheme. So Google said, well, what if we yeet this lines of code and just put it in our software? So, okay, let's read some more. The record indicates that roughly 100 Google engineers worked for more than 3 years to create Google's version of the Android platform software. In doing so, Google tailored the Android platform to smartphone technology, which differs from desktop and laptop computers in important ways. A smartphone, for instance, may run on a more limited battery or take advantage of GPS. Please note the implication that a desktop or laptop cannot take advantage of GPS. The Android platform offered programmers the ability to program for that environment. To build the platform, Google wrote millions of lines of new code. Because Google wanted millions of programmers familiar with Java to be able to easily work with its new Android platform, it also copied, and this is the relevant part of the exercise, 11,500 lines of code from Java SE's program. The copied lines of the code are a part of the tool called the Application Programming Language, or API. What is an API? Well, let's explain it to ourselves. The Federal Circuit described an API as a tool that allows programmers to use pre-written code to build certain functions into their own programs rather than write their own code to perform those functions from scratch. So that was part of the dispute and part of the confusion, right? Because the idea was that what is in the API can be rewritten. It wouldn't be Java anymore, but it can be rewritten because other programming languages have their own API. I mean, many do, and many are created, and so yeah, you can recreate so the idea might be, at least in part, is if the API itself is an expression or not, right? So this was part of the dispute I was having with the chat in the live stream at the time. Because they're like, this is just the equivalent of using words of a dictionary. I'm like, no, maybe it's more equivalent to using the definitions along with the words, which you can't do. And so it's like, yeah, because you can rewrite it in different words. And so Google over here wanted to make this interoperable with Java rather than coming up with their own thing, which they could have done. So they yeeted 11,500 lines of API of this pre-written code so that people would be familiar with it, which may or may not be a problem. So we're going to read on some more. Consider in more detail just what an API does. A computer can perform thousands, perhaps millions, of different tasks that a programmer may wish to use. These tasks range from the most basic to the enormously complex. Ask the computer, for example, to tell you which of two numbers is the higher number, or to sort 1,000 numbers in ascending order, and it will instantly give you the right answer. I'd like to take note here that the sorting the 1,000 numbers in ascending order and instant answer is not necessarily implicit. It depends what your sorting algorithm is, but we'll look past that issue. An API divides and organizes the world of computing tasks in a particular way. Programmers can then use the API to select particular tasks they need for their programs. In Sun API, which we refer to as Sun Java, each of the tasks is known as a method. The API groups somewhat similar methods into classes, and the classes into packages. Yes, I know this very well because Java was my programming language in the long, long ago in the far, far away when I was doing a computer science degree, which is many years in the past at this point. The method, class, package, organizational structure is referred to as Sun Java's API structure, sequence, and organization, or SSO. For each task, there's computer code, known as implementing code, that in effect tells the computer how to execute the particular task you've asked it to perform, such as telling you of two numbers, which is higher. The implementing code, which Google independently wrote, is not an issue here. For a single task, the implementing code may be hundreds of lines long. Yeah, I mean, we all know this, right? We all know that if we're going to write implementing code, right? So if we're going to write a program, right, depending on what the program is going to do and how it's going to be, it could be lots of lines. A method could be lots of different lines. And we know this, we get it. So yeah, if we're going to write implementing code, we're there. We understand that. So if we're going to just copy a program written in Java wholesale, or not necessarily even wholesale because, you don't need it for copyright infringement, we'll just say if we're going to copy something from implementing code, it's going to be a problem. So the question is, what about this declarative code or this API code? Is that different? It would be difficult, perhaps impossible, for a programmer to create complex software programs without drawing on pre-written task implementing programs to execute discrete tasks. Okay, that's just a complete lie. That's just a complete lie. It would be difficult, perhaps impossible, for a programmer to create complex software programs without drawing on pre-written task implementing programs. Not to put too fine a point on it, but there was a time, not that long ago, in fact, within the living lifetime of some of the members of the court, when people didn't have the advantage of pre-existing stuff. They had to write all their own stuff, sometimes with punch cards. There was assembly language and stuff. People wrote some fairly complex stuff in assembly and punch cards, so, it would be difficult, perhaps impossible, for a programmer to create complex software programs without pre-written tasks. Someone talk to the woman who invented Ada. Someone talk to the people who programmed the Apollo lander. Just saying, we got to the moon. So, there's that. No respect for the history of computer science over here. But how do you as the programmer tell the computer which of the implementing codes it should choose, i.e. which task it should carry out? You do so by entering in your own program a command that corresponds to a specific task and calls it up. Those commands, known as method calls, help you carry out the task by choosing those programs written in implementing code that will do the trick. That will instruct the computer so your program will find the higher of two numbers. Good stuff. If a particular computer might perform, say, 1 million different tasks, different method calls will tell the computer which of those tasks to choose. Those familiar with the Java language already know countless method calls that allow them to invoke countless tasks. Yes, people are familiar with the Java language. It is a well-known language. It was the language that yours truly dominantly used in his computer science days in the long, long ago in the far, far away before I became the patent lawyer that you all know and love. So yes, it is fairly well known. And the fact that it's been successful commercially is somewhat suggestive that there's something creative in there, right? Because other programming languages do the same thing functionally, but their APIs are different. So even the declarative stuff is invoking stuff that is written differently. So it's like you don't necessarily have to make function calls to Java, right? There's nothing here that would require Android to run on Java. There's literally nothing. There's zero that would prevent Google from creating its own language. I mean, come on. So this is part of the dispute where I had issues with the chat, which is like, well, this is just dictionary definitions. I'm like, I'm not sure, because someone wrote the API, and when you're making those APIs, man, and you're making those function calls, it's like someone came up with that hard work so that you could make that function call or that declarative call. Maybe come up with your own stuff. I don't know, but we'll read some more. And how does the method call which a programmer types actually locate and invoke the particular implementing code that needs to instruct the computer on how to carry out a task? It does so through creating another type of code, which the parties have called declarative code. So the implementing code calls it declarative code. Let's learn more about that. Declarative code is part of the API. For each task, the specific command entered by the programmer matches up with specific declarative code inside the API. That declarative code provides both the name for each task and the location within the API. That is, the placement of the method within a particular class and particular package, which, I know this all too well. In this sense, the declarative code and the method call form a link, allowing the programmer to call upon thousands of pre-written tasks written in implementing code. Pre-written tasks by somebody else. Without the declarative code, the method calls entered by the programmer would not call up the implementing code, which is true, but you're calling up you're calling up Oracle's declarative code. So there's that. The declarative code therefore performs at least two important functions in the Sun Java API. The first, most obvious function is declarative code enables a set of shortcuts. By connecting complex implementing code with method calls, it allows a programmer to pick out from the API task library a particular task without having to learn anything more than a simple command. It's a shortcut, right? You could rewrite the declarative code. There's nothing that really requires you to make a declarative call to the API. You could just rewrite it. It'd be a pain in the ass, but you could do it. Maybe you should have to do it. Maybe that's part of the issue, right? All right, well, we'll read some more. For example, a programmer building new application for personal banking may wish to use various tasks, say to calculate a user balance or authenticate a password. To do so, they need only to learn the method calls associated with the task. In that way, declarative code's short functioning is similar to a gas pedal in a car that tells a car to move faster, or a QWERTY keyboard on a typewriter that calls up a certain letter when you press a key. I'm not so sure about either of these analogies right now. I'm not sure I buy either of these analogies. But we'll read it again in the hope it makes sense. In this way, the declarative code's shortcut function is similar to a gas pedal in a car that tells the car to move faster, or the QWERTY keyboard on a typewriter that calls upon certain letters when you press a key. You guys can decide amongst yourselves if those analogies are doing anything for you. Typewriter. As those analogies demonstrate, one can think of the declaring code as part of the interface between human beings and the machine. The second, less obvious function is to reflect the ways in which Java's creators have divided the potential world of different tasks into the actual world. That is, precisely which sets of potential millions of different tasks we have our Java computer system perform and how we want those tasks arranged and grouped. In that sense, the declarative code performs an organizational function. It determines the structure of a task library that Java's creators have decided to build. To understand this organizational system, oh my God, think of the Dewey Decimal System that categorizes books into accessible systems, or a travel guide that arranges a city's attractions into different categories. Language itself provides a rough analogy for declarative code's organizational features. For language itself divides into a set of concepts, a world that in certain respects other languages might have divided differently. Well, that's true. I mean, different languages do conceptualize things differently on a fundamental level sometimes. The developers of Java, for example, decided to place a method called drawImage instead of a class called graphics. Yeah, there's that. Consider a comprehensive, albeit far-fetched analogy. Oh my God. Okay, guys. Brace yourself. Brace yourselves. You guys have to strap in here. Okay? You guys are going to have to strap in here. Because Justice Breyer, which earlier, without analogy, apologize, let's try that again. Justice Breyer, which earlier, without apology, analogized a declarative call to a gas pedal in a car or a key on a typewriter, has said that he's about to go into a far-fetched analogy. So if the typewriter and gas pedal wasn't far-fetched, what might be far-fetched? You want to enter any bets at this point? This would be fun. Try not to have a stroke with me. Here we go. Oh, Lord. Consider a comprehensive, albeit far-fetched analogy that illustrates how API is actually used by a programmer. Imagine that you can, via certain keystrokes, instruct a robot to move a particular file cabinet, to open a certain drawer, and to pick out a specific recipe. With the proper recipe in hand, the robot then moves to your kitchen and gives it to a cook to prepare the dish. This example mirrors the API task-related organizational system. Through your simple command, the robot locates the right recipe and hands it off to the cook. In the same way, typing a method call prompts the API to locate the correct implementing code and hand it off to your computer. And importantly, to select the dish that you want for your meal, you do not need to know the recipe's contents, just as a programmer using an API does not need to learn the implementing code. In both situations, learning the simple command is enough. Okay, you guys, again, can decide amongst yourselves whether the robot fetching recipes from a file cabinet and handing off to a cook is anything like declarative code. You guys can argue amongst itself because apparently it mirrors that. Mirrors it. Is that doing anything for you guys over here? Is it doing anything for my fellow computer people over here? Yeah. I did not bring a strong enough beer for this party. Now, let us consider the example that the district court used to explain the precise technology here. A programmer wishes, as part of the program, to determine which of two integers is larger. To do so in the Java language, they will first write java.lang. Those words, which we've put in bold type, refer to the package, or by analogy, the file cabinet. They will write math. That word refers to the class, or by analogy, the drawer. They will then write max. That word refers to the method, or by analogy, the recipe. They will then make two parentheses, and in between the parentheses, they'll put two integers, say 4 and 6. They wish to compare. The whole expression, the method call, will look like this: java.lang.math.max 4, 6. This use of expression will, by means of the API, call up a number of task implementing programs that will determine the higher number. In writing the program, the programmer will use the very symbols we placed in bold in the precise order we've placed them. So okay. But the symbols themselves do nothing. That much is certainly true. They must also use software that connects the symbols to the equivalent of file cabinets, drawers, and files. The API is that software. It includes both declarative code that links each part of the method call to a particular task implementing program and the implementing code that actually carries it out. For illustration, see Appendix B. If you guys are good, we may see an illustration of this through Appendix B. I will take note that sadly, apparently, we are not going to be graced with an illustration of the robot featuring fetching recipes. That's yeah. Now let's return to task of copying at issue at hand. Google did not copy the task implementing programs or implementing code from Sun Java API. It wrote its own implementing programs, such as those that would determine which of two integers is greater or carry out any desired or far more complex task. This implementing code constitutes the vast majority of Sun Java API and the API that Google created for Android. For most of its packages in the API, Google also wrote its own declarative code. For 37 packages, however, Google copied the declarative code from Sun Java. So one will take note here for the legal analysis, for whatever it's worth here, one will take note that Google did write declarative code and its own versions of declarative code. So it apparently is well able to do this and apparently saw advantages to doing it. And then in 37 cases, it's like, let me just yeet the declarative code from Java. Even though I know how to write my own and I could write my own, let me just borrow theirs. So, this is kind of because, I kind of thought Oracle might have the better end of the case. As I mentioned in the stream when I did this, I thought Oracle might have the better end of the case. And this is kind of why. It's like, if you want to call Java, you have to use these things. But that kind of presupposes the premise, right? It's like, why do you have to do this? Google doesn't have to. They could have written their own declarative code. They apparently are well able to. So why they have to write it for these 37? I mean, it would have been a little inconvenient to rewrite the 37, I guess, but it's not like they couldn't do it. I mean, in the grand scheme, how hard could it be? I mean, the 37 things they copied was apparently 11,500 lines of code. How hard would it be for Java to write the equivalent of 11,500 lines of code? So it's like, there's something there, is all I was saying. As just explained, that means for those 37 packages, Google necessarily copied both the names given to the task and the grouping of those tasks. In doing so, Google copied the portion of Sun Java API that allowed programmers experts in the Java language to use the task calling system they already learned. One will also take note here that there would be nothing stopping Google from using a very similar format, right? You'd just call them different things and it would be different code. Like if you like the taxonomy, right? If you like the hierarchical taxonomy of Java, you can borrow that. I mean, there's nothing special about that. It's just taxonomy. So if you want to have 1.2.3, no problem. Just come up with your own things, right? So taxonomy isn't copyrightable. You could borrow that. Just come up, maybe you come up with your own stuff. I don't know. As Google saw it, the 37 package at issues include those tasks that were likely to prove most useful to programmers for applications for mobile devices, which kind of, in my view, respectfully, cuts against. Because if they are the most useful ones, right? If they're the most useful ones, In fact, three of the packages were fundamentally able to use the Java language at all. By using the same declarative code for those packages, programmers using the Android platform can rely on those method calls that are already familiar with them to call up a particular task, such as determining which of two integers are greater. But Google's own implementing programs carried out the task. Without that copying, programmers would need to learn an entirely new system to call up the task. Yeah, they would, but that's kind of true of pretty much all the programming languages ever. So, yeah. We add up the Android platform has been successful. Well, that's true. Within 5 years of its release, Android developed a large share of the US market. As of 2015, Android sales produced more than $42 billion in revenue. In 2010, Oracle bought Sun. Soon thereafter, Oracle brought this lawsuit. Great. So now we've learned a lot about the history. Fun stuff. All right. This case has a complex and lengthy history. At the outset, Oracle complained that Java's use of Sun Java API violated both copyright and patent, which is how this got to the Court of Appeals for the Federal Circuit, because they hear all the patent cases. Now, one might wonder whether or not they brought the patent cases specifically to get the copyright issue heard by the Federal Circuit. Like maybe it's possible, potentially, that our friends over here brought a patent claim not because they really wanted the patent claim, but because they knew that if they brought the patent claim, it would have to be heard by the Court of Appeals for the Federal Circuit. Maybe they didn't want this to be heard by the Court of Appeals for the Ninth Circuit And so maybe it's possible, perchance, they brought the patent claim so it wouldn't be heard by the Court of Appeals for the Ninth Circuit, and instead be heard by the Court of Appeals for the Federal Circuit, which has a bit of a reputation for being a little bit IP maximalist, which I'm sure had no factor in the decision. Maybe that had something to do with it. For its copyright claim, Oracle alleged that Google infringes copyright by copying the 37 package, both the literal declaring code and the non-literal organizational structure of the API. The groups insert methods in the class and classes in the package. That's not going to fly. For trial purpose, the district court organized 3 proceedings. The first would copy the copyright, the second would discuss the patent, and the third would, if necessary, calculate damages. The court also determined that a judge should decide whether copyright law could protect an API, which, is a legal question. Whether it's subject to copyright is a legal question. It's nothing to do with the facts. And a jury should decide whether Google's use is fair use. Okay, great. After 6 weeks of hearing evidence, the jury rejected the patent claims, which has since dropped out of the case, which I'm sure were in no way there merely to direct this vehicle to the Court of Appeals for the Federal Circuit, because they have a bit of a reputation for being IP maximalists. It also found a limited copyright infringement. It deadlocked as to whether Google could successfully assert fair use. The judge then decided, regardless, the API declaring code was not the kind of creation to which copyright law extended its protection. The court noted that Google had written its own implementing code, which constituted the vast majority of API. It wrote that anyone is free under the Copyright Act to write his or her own code to carry out the exact same task that Sun Java had picked out or specifics. Google copied only the declarative code and organizational structure that was necessary. The organizational structure is not copyrightable. There's no way, because it's just a taxonomy. It's like saying, that biology taxonomy is copyrightable, which is kind of similar, I guess. Or saying that Dewey Decimal, which I guess has a similar taxonomy, is copyrightable. No. You can't just say because there's a hierarchy, that doesn't make sense. You can't say there's a copyright in the structure. That doesn't make sense. Copyright in the code, though, I'm a little bit more friendly to. Okay. Hence, the copied material in the judge's view was a system or method of operation which copyright law says it cannot be copyrighted, which is a fair legal opinion, right? So, that is an operative legal opinion, whether or not the API is copyrightable. Now, we haven't really discussed that, really, so far in yours discussion so far, because the court, for some reason that passes my understanding, just blew completely by the issue, which is a little bit disappointing. Because all this time, I've been speaking to you like the API and like the declarative code is copyrightable, which is an assumption. It's also an assumption the court is making. I'd like to take notes, so I'm in good company. But yeah, the Copyright Act 102B specifically says systems and methods of operation are not copyrightable. So there is, in my view, so regardless of the fair use issue, which is another issue we're going to come to, right? So regardless of the fair use issue, which is issue number 2, fair use only applies if it's copyrightable. You can't have a fair use analysis without a copyright. It doesn't even make sense. So regardless of whether you and I disagree on the fair use analysis, and regardless of whether or not we disagree on some of these details, there's still the looming issue of whether or not the API and declarative code is copyrightable at all. Because there's a very non-trivial legal view here that it's a system and method of operation. And, we are not going to get any resolution on that issue, which is disappointing for all of us, including me and including you. We are not going to be further legally clarified today on that issue. It's very, very sad. Very sad. So we do not know whether APIs or declarative code are copyrightable or not. That's great. That's just super. On appeal, the Federal Circuit reversed. The court held that both the API declarative code and its organizational structure could be copyrighted. I'd have to go back and reread the Federal Circuit decision on the organizational code and see if it makes any sense, because I'm dubious. It pointed out that Google could have written its own declarative code, just as wrote its own implement code, which is a fair conclusion because Google did. They did write their own declarative code, a lot of it. So yeah, they could have done that. That's fair. And in principle, Google might have created a whole new system of dividing and labeling tasks that could have been called up by programmers. Yeah, but it's a taxonomy, so I don't buy that. The Federal Circuit also rejected Oracle's plea that it decide whether Google had a right to use the API because doing so was a fair use, immune from copyright liability. Yeah, so the Federal Circuit's kind of the opposite way around here. That's great. The Federal Circuit over here is like, oh, it's totally copyrightable, and we're not going to analyze fair use. The Supreme Court's like, oh, it's totally fair use, and we're not going to analyze whether it's copyrightable. Here's a thought. What if a court actually analyzed both issues? Ooh, we're not going to do that today. The circuit wrote that fair use both permits and requires courts to avoid rigid application of the copyright statute, when on occasion would stifle the creativity, which is designed to foster. But it added, this is not a case in which the record contains sufficient factual findings on which we could base a de novo assessment of affirmative use of fair use, and remanded the case for another trial on that specific question. Google then petitioned this court for a writ of certiorari about this question. We denied that. So on remand, on the fair use question, because why not, the district court, sitting with the jury, heard evidence for a week. This whole thing is bizarre because fair use is ultimately a legal question. Presumably, never mind. All right, let's just press on. The court instructed the jury to answer one question. Had Google shown by a preponderance of the evidence that its use of Android or declarative code that it constitutes fair use? How is this a jury question? After 3 days of deliberation, jury answered in the affirmative. Google has shown fair use. Google then appealed to the Federal Circuit, and the Circuit again reversed the district court. The Federal Circuit assumed all the factual questions in Google's favor, but it said the question of whether this fact constitutes fair use is a question of law, which of course it is. Deciding that question of law, the court held that Google's use of Java API was not fair use. It wrote that there's nothing fair about taking a copyrighted work verbatim and using it for the same purpose and function as the original in a competing platform. It remanded again for this case on trials. So this may or may not be, depending on your point of view, equivalent to the Dr. Seuss story, which we posted earlier today, which just happened to be a fortuitous thing that we have 2 copyright stories in a day. So for you copyright people who really, really like copyright law, you're getting a 2 for today. Yeah, it's earlier today you got a copyright dealing with Dr. Seuss, and today you're getting copyright on computer code. I'm the greatest copyright lawyer. Yeah, we know. I love you, Leonard French. Sorry. Okay, Oracle then again appealed to the Federal Circuit and again reversed. The Federal Circuit says a question of law. Then they file a petition. We grant the petition. Great. Let's learn a little bit about copyright and patent law and what it's for. Copyrights and patents, the Constitution says, are to promote the progress of science and the useful arts by securing for a limited time to their authors and inventors the exclusive rights to their writings and discoveries. Copyright statutes and case law have made it clear that copyright has practical objectives. It grants an author an exclusive right to produce his work, sometimes for 100 years or more, not as a special reward, but in order to encourage the production of works that others might reproduce more cheaply. At the same time, copyright has negative features. Protection can raise prices to consumers. It can impose special costs, such as the cost of contacting owners to obtain reproduction permission, and the exclusive rights of its awards can sometimes stand in the way of others exercising their own creative powers. Some guy once said that the principle of copyright is a tax on readers for the purpose of giving a bounty to their writers. Congress, in their infinite wisdom, weighing the advantages and disadvantages, will determine the more specific nature of this tax, its boundaries and conditions, the existence of exceptions and exemptions, all by exercising its constitutional power. 4 provisions of the current Copyright Act are particularly relevant. First, a definitional provision sets forth 3 basic conditions. There must be a work of authorship, it must be original, and it must be fixed. Second, the statutory lists certain kinds of works that can be protected. This includes literary, musical, dramatic, motion picture, architectural, and certain other works. In the 1980s, Congress expanded the reach of copyright to include computer programs, and it defined computer programs to mean a set of statements or instructions to be used directly or indirectly in a computer in order to bring a specific result. Which may or may not conflict with the 102 definition about, functions and all the rest of it. So, maybe there's some tension there. Third, the statute forms limitations on that work that can be copyrighted, including works that definitional provisions might otherwise include. The copyright law says, for example, copyright cannot extend to any idea, procedure, process, system, method of operation, concept, principle, or discovery. These limitations, along with the need to fix it in a tangible medium, have often led courts to say in shorthand that unlike patents, which protect novel and useful ideas, copyrights protect expression, but not ideas. That's pretty much true. Yeah, copyright does not protect the idea. Patent more closely protects the idea. Yeah, but not completely, but more closely. Fourth, Congress, together with the courts, have imposed limitations on the scope of copyright, even in respect to works that are entitled to copyright. For example, the Copyright Act limits an author's exclusive rights in performance and displays, or to performances of sound recordings. And directly relevant here, a copyright holder cannot prevent another person from making a fair use of the material. We've described fair use doctrine originating in the courts, which is true, before it was codified in the statutes. So this is an example of courts inventing law, which may or may not, courts invented fair use, and then later it was codified. So, there's that. So, yeah. So it started off its life in the courts before it was ever in statute. We've described fair use, originating in courts, as an equitable rule of reason that permits courts to avoid rigid application of copyright when on occasion it would stifle the creativity which copyright law is designed to foster. The statutory provision that embodies this doctrine indicates how fair use is to be analyzed, which we all know very well, so we'll skip. In applying that provision, we, like other courts, have understood the provision of factors is non-exhaustive, which it's not. The examples it sets forth do not include other examples, and some factors may prove more important in some contexts than others. In a word, we've understood the provisions to set forth general principles, the applications of which require judicial balancing, dependent upon relevant circumstances, including significant changes of technology, which incidentally is what makes it very, very hard for a lawyer to answer the question of what is fair use in the abstract. Right? It's like, can you provide me examples in the abstract of what's fair use? Not really, because anything in the abstract may or may not be fair use depending on a whole bunch of things. So the answer is it depends. Can you provide me a list of fair things? Not really. But for the low, low price of an opinion letter, I can tell you the answer to any specific thing. Or I can give you a best guess at least. Google's petition for certiorari provides two questions. The first asks whether API is copyrightable, which is kind of an important question that we're going to ignore. It asks us to examine the two provisions we just mentioned, one that permits copying of computer programs and the other that forbids copying processes, terms, and methods. Google believes its API code and organization falls into the latter and are expressly excluded from copyright. The second question asks us to determine whether it's fair use. Google believes it was. A holding for Google on either question would dispense with the claims. True. Given the rapidly changing technology, economic, and business-related circumstances, we believe we should not answer more than is necessary to resolve the dispute. Lame. We shall assume, but purely for argumentative sake, so please take special note, we are not deciding this, that the entirety of the API falls within the definition of copyright. Yeah. We shall instead ask whether Google's use of that constitutes fair use. Unlike the Federal Circuit, which gets overturned, which, shocker, because it gets overturned all the time, we conclude it is. Are we having fun so far? Are we having fun? Are we having a good time here with the Google Oracle API? I'm having fun. I hope you're having fun. For the 103 of you who are currently watching, please remember to like the video. I do these things for you and so that you understand law. And we can discuss it and explore my own thoughts and explore the court's thoughts and, understand these things better and all the rest of it. So, hopefully this is illuminating and somewhat entertaining because I try. I try very hard to make some sort of dry stuff a little bit more interesting and bring it a little bit more flair. Bring that personality to it because, that's part of my goal here. So make it interesting. How am I doing? Charles says he thinks he's lost. Well, ask for help from the chat, Charles. I don't know what you're lost about. So, ask for help from the chat. Maybe they can help you. The language of the fair use provision reflects its judge-made origins. It's similar to that from Justice Story. That background, as well as modern courts' use of the doctrine, makes clear the concept is flexible, that courts must apply it in light of the sometimes conflicting aims of copyright, and its application may well depend on context, which, Thus, copyright protection may be stronger where copyright material is fiction, not fact, where it constitutes a motion picture rather than news, or it serves artistic rather than utilitarian function. Similarly, courts have held that in some circumstances, say where copyright material is bound up with uncopyrightable material, copyright protection is thin. This is citing Feist, which is the phone book case. So facts are not copyrightable. Phone books, as you might appreciate, constitute facts. So that's a lot of non-copyrightable material. But what's copyrightable about a phone book? Its arrangement, its fonts, its stylizations, its formats, how it presents the material, so forth and so on. So in those cases where, it's not much, then the courts look at it as very thin. It's copyright, but not much of one. Generically speaking, computer programs work differently from books, films, and many other literary works, so in such that programs almost always serve functional purposes. That's true. If you had a non-functional program, come on. These and other differences have led some judges to complain that applying copyright law to computer programs is like assembling a jigsaw puzzle which pieces do not quite fit. That's totally fair. Because computer programs are functional ultimately in their nature, right? So if the copyright law does not extend to methods and processes and all the rest of it, right, then computer programs would seem not to be copyrightable. But we know that's not true because it specifically says they are copyrightable. So the courts in trying to wrestle this have had the same confusion you or I would have in this situation. It's like, well, we have a provision saying code is not copyrightable and one that's saying this is. So let's square that circle. Super fun for all. Good times. These differences also led Congress to think long and hard about whether to grant copyright to computer programs. In 1974, Congress established a National Commission of New Technological Uses of Copyrighted Works, CONT2, to look into the matter. After several years of research, CONT2 concluded that the availability of copyright protection for computer programs is desirable. At the same time, it's recognized that computer programs have unique features. Mindful of not unduly burdening users of programs and the general public, it wrote that copyright should not grant anyone more economic power than is necessary to achieve the incentive to create. Well, if that was true, if that was really true, that copyright law should not extend more power than is necessary to innovate, man, I think we could seriously talk about dramatically reducing copyright terms, for example. I'm not sure there's a lot of people out there to take, for example, the most recent extension of the Copyright Act. I'm not sure there's a lot of people out there who said, life plus 70 isn't going to do it for me, but life plus 90, that's what I'm all about. I'm not sure there's a lot of people who say, well, I won't create for life plus 70, but that life plus 90 life, yo. Yeah. Well, let's blow past that. And it believes that several existing doctrines, for example, fair use, applied by the courts on a case-by-case basis, could prevent holders from using copyright to stifle innovation. Congress then wrote a computer program protection into law. The upshot, in our view, is that fair use can play an important role in determining the lawful scope of computer program copyright, such as the copyright issues here. It can help distinguish among technologies. It can distinguish between expressive and functional features of code when those features are mixed. Very mixed. Very mixed. Computer program code and the difference between expressive and functional. Very mixed. Good times. Enoch Alliance says, what the F is this? This would be a Supreme Court Eknock. Yes, we are a legal discussion channel. Eknock, we are discussing law. The name of the channel is Uncivil Law, as you might have noticed. We are discussing a recent decision from the U.S. Supreme Court, which is discussing copyright law related to copyright in API computer code, and whether or not declarative functions are copyrightable or not. Hopefully that clarifies what we're discussing here, Enoch. I thank you for joining us. In a word, it can carry out basic purposes of providing context-based check that can help keep copyright monopoly within lawful bounds. Justice Thomas thoughtfully dissents and offers a very different view of how and perhaps whether fair use has any role to play in computer programs. Presumably, yes. We are told that no attempt to distinguish among computer code is tenable when considering the nature of the work, even though there are important distinctions in ways that programs are used in design. We are told that no use of code will ever have a valid purpose and character, even though reasons for copying computer code may vary greatly and differently from those applicable of other kinds of works. And we're told our fair use analysis must prioritize certain factors over others, even though our case law, it depends on the use of the context. We do not understand Congress to have shielded computer programs from ordinary application of limiting doctrines. By defining computer programs in Section 101, Congress chose to place the subject matter within the copyright regime. Like other protected works, that means owners of computer codes enjoys the exclusive right, including the right to reproduce the work or prepare derivative work. But it also means the exclusive rights are limited, just like any other work, just as fair use distinguishes among books and films, which are indisputably subjects to copyright, so it must draw lines among computer programs. And just as fair use takes account of the market in which scripts and paintings are bought and sold, so too we must consider the realities of how technology works and created and disseminated. We do not believe the approach to all or nothing will be faithful to copyright's overall act design. Yeah, I mean, that totally makes fair. It's a little bit odd. And maybe we'll skim Justice Thomas's opinion, but it's a little bit odd to conclude that fair use doesn't apply at all, because that's a very strange conclusion, because, Section 107 isn't limited anyway, so I'm not sure how you necessarily get to that conclusion that there's no such thing as fair use in this domain. That's a little bit weird. At the outset, Google argues that fair use is a question for a jury to decide. Here, the jury decided the question in Google's favor, and we should limit our review to determining whether substantial evidence justifies a jury decision. The Federal Circuit disagrees. It thought that the fair use question was a mixed question of law and fact, which it is. The reviewing court should appropriately defer to the jury's finding of facts, which it should, and the ultimate conclusion of those facts is legal, which it is. We agree with the Federal Circuit's answer to this question. We've said fair use is a mixed question of law and fact, which of course it is. We've explained that a reviewing court should try. Now, that being said, that fair use is a mixed question of law and fact. Let me tell you, as a person who his entire practice is before the Federal Circuit, because patent law, right? All the cases go to the Federal Circuit eventually, right? There's only one path. So let me tell you that when the Federal Circuit says it's a mixed question of law and fact, the Federal Circuit has a tendency, in my view, to sort of think everything's kind of a legal question. They don't really, in my humble opinion, really divide that well in the mixed question analysis and respect the different domains. They say things are a mixed question of law and fact, but in reality, they seem to act like everything's a legal question. Just in my opinion. This is also, incidentally, in my view, why the Supreme Court of late, including this opinion we're discussing right now, has been slapping the Federal Circuit around. Because the Federal Circuit is definitely the current whipping boy of the U.S. Supreme Court. On whole. It used to be the Ninth Circuit, right? The Ninth Circuit used to be the whipping boy of the Supreme Court for a long time. The Ninth Circuit had the record, right? And these days it's the Federal Circuit. The reason it's the Federal Circuit is because for about 25 years, from 1981 to which it was created to about 2006, so about for 25 years, there or thereabouts, there were basically no appeals that were granted from the Federal Circuit to the U.S. Supreme Court. There were no appeals, right? Everything stopped at the Supreme Court. Everything stopped at the Federal Circuit. So the Federal Circuit got a big head, and they thought to themselves, we're the Supreme Court. We're the Supreme Court. We're the best court. No one can challenge us. And basically, for the last 15 years, the Supreme Court has been trying to whack them around and remind them, who's king chicken? We're king chicken. So this is another example of the Supreme Court whacking the Federal Circuit around and trying to remind them that they are not actually the boss. If the Supreme Court wanted to, they could actually just walk over to the Federal Circuit and literally slap them in person. The Federal Circuit is right next to the White House. Well, it's pretty much right next to the White House. I've been there many times. The Supreme Court could just walk out of the building, just walk over to the Federal Circuit and slap them in the face in person. It would probably save time. Maybe they should look into it. Just saying. In this case, the ultimate fair use question primarily involves legal work. Fair use was originally a concept fashioned by judges. Our case still provide legal interpretations for fair use, and those interpretations provide general guidance. This type of work is legal work. Applying fair use conclusion may, of course, involve a determination of subsidiary factual questions, such as whether the harm to actual potential markets for the work or how much the copyright work was copied. In the case of the Federal Circuit, carefully applying the fact law principles, leaving factual decisions to the jury, and reviewing the questions, a legal question de novo. Next, Google argues that Federal Circuit approach violates the Seventh Amendment. This should be good. The amendment provides that the right to a jury shall be preserved and forbids courts to re-examine any fact tried by a jury. The re-examination clause is no bar here, however, for we've said the ultimate question is one of law, not fact, which of course it is. It does not violate the re-examination clause for a court to determine the controlling law and resolve a challenge to a jury verdict, as happens any time a court resolves a matter for a judgment of law. Yeah, this is super lame. This is super lame. Google says that you can't do this because you can't re-examine facts by a jury. And the court points out the obvious of we're not doing that. We assume every single fact that is favorable to the verdict. Because of course we do. That's what we're supposed to do. The Supreme Court, examine every fact favorable to the verdict. Maybe less so the Federal Circuit, but we do. And we assume every fact, and then we're just going to say, as a matter of law, those facts aren't enough. That's not re-examining the facts. It's saying the facts are not enough. Like every motion for summary judgment or every motion for a judgment notwithstanding the verdict. Like ever. So, no. Just no. Nor is Google correct that the right of trial by jury includes the right to have a jury resolve a fair use defense. That clause is concerned with a particular trial decision at issue, even though it's possible to find pre-revolutionary English cases in which a judge sent related questions like fair use abridgment to a jury. Those questions were significantly different from the fair use doctrines courts apply to today. So, fair enough. What they did in fair use land in England is not comparable. I'll take their word for it. As for contemporary fair use is concerned, we've described the doctrine as equitable, not legal. That's an interesting proposition. It absolutely doesn't matter in any way, but let me consider whether or not I agree with that. This so doesn't matter. But we're here for my entertainment too. Okay, so first of all, what is the difference? I guess we could discuss that briefly. All right. So in the long, long ago, in the far, far away are the courts of England, and I think 3 states today for reasons that pass my understanding. There used to be courts of law and courts of equity. These are different things, right? So I can give you an example of the difference in law and equity, right? So I'll give you a difference. All right. Legal concept, contract. Equitable concept, promissory estoppel. All right. So you and I have a contract. We're in breach of the contract. That's a legal issue. All right. So what if we don't have a contract? Well, then presumably no legal issue, right? Because there's no contract. So the courts created equitable concept like promissory estoppel. What is promissory estoppel, you ask? I'm so glad you asked. Basically, promissory estoppel is where I make a series of promises to you, and in reliance on those promises, you undertake a series of steps to gain that promise. So it's like, I'll give you an example where this could apply in the abstract. Please take note, I'm not saying that this applies in your case if this applies to you, asterisk, asterisk, asterisk. All right, here's a situation where this could theoretically apply. Let's suppose a company offers you a job, and let's suppose the job is in a different part of the country. They say, well, not strictly speaking, they've offered a job. Let's say that they've said, we know for sure we're going to have a opening in 6 months. You are by far and away our favorite person for this new position. We cannot think of anyone better who could possibly have it. We know for sure we're going to have this position. We definitely want you. It's really super, super important to us. And in order for you to have this job, though, because, we're in the pre-existing times before COVID, in order for you to have this time, we need you to move across the country to our city, to do this, and because you have a home or something, right? So you have a home and stuff. It's like, I can't get the job. I can't move there. It's like, well, we'll give you a lot. We'll give, we'll give you the big pile of money so you can sell your house and move your kids and all the rest of it. So basically you go through all that process, right? You sell your house and you get your kids out of the schools and blah, blah, blah. And you move to the big city. And then the day comes and the job is no longer available. Like they've given it to someone else, or they change their mind or whatever. So this might be a promissory estoppel, right? They've made you a promise, right? There's no exchange of consideration. You didn't give them any benefit, right? So there can't be contract. So they made you a promise, we'll give you the job, but you haven't given them anything in return. So there can't be a contract. Like there's only one half of the contract. There's promise. There's nothing going the other way. So you have engaged in a detriment to yourself. You sold your house, you upended your life, blah, 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 to move across the country for this job. So there isn't a contract theory, but there might be promissory estoppel, right? You made a promise to me. I've engaged in a detriment in reliance on that promise. So you were stopped. You're prevented from doing that. So you might have to pay me some kind of damages to make me whole, right? It's equitable. So that might be like, you might have to pay me enough to undo this. You might have to pay me enough for me to find a different job equivalent, but there's something along those lines, right? You have to pay some way in order to even out these scales. All right. That's the difference between law and equity. So yeah. So in the long ago, in the far, far away, there are these two different courts. And then in the US, they mostly combine them, so it doesn't really matter anymore. So in the beginning, when fair use was being created, it was equitable. It had to be, because it wasn't legal, because there wasn't a law, right? So it had to be an equitable doctrine, right? I mean, what's the alternative, right? So they created an equitable doctrine called fair use. Then eventually Congress adopts it into law. And so here's the question, which I've been spending a very long time asking, even though it doesn't matter, because I'm just interested by it, and this is as much education for me as you. It's like, when Congress adopted it as law, or they adopted it as statute, did it stop being equitable and start being legal? Now, I would think the answer to that question is yes, because, now it's codified in a law, but apparently the Supreme Court over here still thinks it's equitable, even though it's in a statute, which is an interesting concept that entertains me. So we can go past that diversion, which has been a little while now, and go back to the case. Sorry about all that. Sorry, but not sorry. We found no case suggesting the application of U.S. Bank here would fail to preserve the substance of the common law right as it existed in 1791. No, that doesn't begin to make sense. We have now turned to the basic legal question before us. Was Google's copying of Sun API, specifically its use of declarative code for its 37 packages of API, a fair use? In answering this question, we shall consider the 4 factors of fair use and apply them for the computer programs. So this is pretty interesting. So this decision going forward is a pretty significant one. It's pretty significant on its own terms, obviously, but it's perhaps even more significant because it's a fair use analysis of computer code at the Supreme Court level. So we can obviously abstract from the issues before us and abstract to like all computer code, right? Because it's a computer code case. So you can bet your bottom dollar that every fair use case going forward for the rest of time until the Supreme Court decides another one will be using this case to draft its model of what fair use looks like. So this case is important to the current issue. And I think really, truly, I really think it's much more important in the grand scheme going forward. Because this is the only Supreme Court case that exists on fair use of computer code. It's got to be kind of important, right? So yeah, there's that. So yeah. So let's spend a little time here understanding that. All right. So what is the nature of the copyrighted work? All right. So I'm going to answer these questions first to see if my answer, how it compares to the Supreme Court. All right. So nature of the work. And when we're asking the nature of the work question, we're typically asking between a work of fiction and a work of fact, right? Is this a telephone book or is this Harry Potter? Or somewhere in between. So where is this in this continuum? Now, that's a good question. I don't think you can say they're pure facts because it's not like, before computer code exists. Someone had to create the first computer code ever, right? Someone had to create the first API ever. So how can they be facts, right? They're concepts. There were always concepts distilled, right? So are they a work of fantasy? They're more a work of fantasy than not. I don't know. We're quite into Harry Potter territory, but yeah, we're somewhere in the middle. So we're somewhere in the middle between fact and fantasy, and I don't know which end of the equation it leans more on. Maybe a little bit more on the fact side. We'll see what the Supreme Court says. All right. The Sun Java API is a user interface. It provides a way through which users, hereinafter called programmers, that's great, can manipulate and control task performings by the computer program via a series of menu commands. Okay. The API reflects Sun's division of possible tasks a computer might perform in a set of actual tasks that certain kinds of computers will perform. Sun decided, for example, that its API will call up a task that compares one integer with another to see which is larger. We're really loving the which number is bigger in example. Sun's API, to our knowledge, will not call up the task of determining which Arabic scholar decided to use Arabic numbers rather than Roman numerals to perform the larger integer task. What? Okay. My brain stopped. Let's try again. All right. Sun's API, to our knowledge, will not call up the task of determining which great Arabic scholar decided to use Arabic numerals rather than Roman numerals to perform the larger integer task. I agree. The computer, in trying to determine which number is bigger, is probably not going to try to figure out who invented the numbers. Okay. All right. No one claims that decisions about what counts as a task are themselves copyrightable, although one might argue about decisions as how to label and organize such tasks. As discussed above, we can think of technology as having three essential parts. First, the API includes implementing code, which actually instructs the computer on steps to follow to carry out each task. Google wrote its own programs that perform each one of the tasks the API calls up. Second, the Sun Java API associates a particular command called a method call with the calling up of each task. The symbol, java.lang, for example, are part of the command that will call the program. That instructs the computer to not carry out a large number operation. Oracle does not here argue the issue of those commands programs itself violates the copyright. I apologize, I'm not going to get this right. I'm messing this up. Astaroth K. I think I got it finally. Astaroth K says, trying to own a computer code is like trying to own a language. Well, with all due respect, I think that you can copyright a constructed language. Now, that doesn't mean you can copyright the use of the language, but you can copyright the language because the language is itself an invention of fantasy. So I think you can copyright an invented language because, I mean, it's a work of creativity. I mean, to invent a language, it's got to be, right? So if you came up with a completely new language, like, for example, Tolkien did, for example, I think he could have a copyright in the underlying language, especially to the degree that it was sufficiently explained in detail. This might apply a little bit more to really constructed languages. So yeah, you probably can copyright a completely constructed language, although not necessarily its use of the language, but yeah, you can copyright the language itself. That might make sense. So yeah, that makes sense. I think you can copyright the Java language. I mean, it's invented. It's a work of creativity. Why not, right? That doesn't mean that there's not fair use to be had, but yeah, I mean, someone created Java. There's some creativity in there somewhere. Second, the Sun Java API associates a particular command called a method call with the calling up of each task. The symbols, java.lang, for example, are part of the command that will call the program. That instructs the computer to carry out a larger number operation. Oracle does not argue the use of these commands itself violates copyright. Okay. Third, the Sun Java API contains computer code that will associate the writing with a particular place in the computer that contains the needed implementation. This is declaring code. The declaring code both labels the task and organizes those tasks or methods into packages and classes. Excuse me. We've referred to this organization by way of rough analogy as file cabinets, drawers, and files. Oracle does claim that Google's use of the API declaring code violates its copyright. The declaring code at issue here resembles other copyrighted works in that it's part of a computer program. Congress has specified computer programs are subject to copyright. It differs, however, from other kinds of computer code. It's inextricably bound together with a general system, the division of copying tasks that no one claims is a proper subject of copyright, and it's inextricably bound up with the idea of organizing tasks into what we have called cabinets, drawers, and files, an idea that's not copyrightable. Yeah, taxonomy is not going to work. It's the idea of taxonomy. Let me be clear here so that I'm not misunderstood. The idea of a taxonomy, the hierarchy of a taxonomy is not compatible. The specific taxonomy might be copyrightable. So again, this is the idea of the idea expression economy. So if you came up with a fake biology of fake creatures and you organize them into a taxonomy, like, yeah, you can do that and it'd be copyrightable for the stuff. It's just not the taxonomy itself. The actual structure is not copyrightable, but like every part of it is in sort of its separate form. So, yeah. It's inextricably bound up with specific commands known to programmers as method calls, such as java.lang.math.max, that Oracle does not contest, and it's inextricably bound up with implementing code, which is copyrightable but was not copied. Moreover, the copying of declared code and uncopied implementing code calls for and reflects different kinds of capabilities. A single implementation may walk a computer through dozens of different steps. To write implementing programs, witnesses told the jury, requires balancing such considerations as how quickly a computer can execute a task or the likely size of memory. One witness described the creativity as magic practiced by an API when he or she worries about things like power management for things that run better. That's probably more true. That's probably more true than most programmers want to admit. That's probably more true than most programmers want to admit. How does the program work? Magic. I think if some programmers were out there really honest with themselves, how's this code working? I don't know. How's this thing working? The magic smoke. The magic smoke makes computers work. Yeah, the magic smoke is the reason computers work. Without the magic smoke, no computer would work, don't you know? It's all about the magic smoke. For those of you who don't know what I'm talking about, you're not part of the Cool Kids Club. One witness described, this is very creativity was needed for the Android software to use not in laptops or desktops, but in a very different context of smartphones. The declaring code, inseparable from programmer method calls, embodies a different kind of creativity. Sun Java creators, for example, tried to find declarative code names that would prove intuitive and easy to remember. They wanted to attract programmers who would learn the system, help development further, and prove reluctant to use another. Yeah. They wanted to attract It must be designed and organized in a way that's invocable and understandable. Sun's business strategy originally emphasized the importance of using API to attract programmers. It sought to make the API open and thus compete on implementation. The testimony trial was replete with examples of witnesses drawing this critical line between user-created declarative code and innovative implementing code. These features means that as part of the user interface, the declarative code differs to some degree from the mind run of computer programs. Like other programs, it's functional in nature, which, but unlike other programs, its use is inherently bound together with uncopyrightable idea. I don't think anyone can contest that. Of course it's an idea, the core of it. Of course it's an idea. Everything begins with an idea, including the declarative code, including the program. I mean, everything is an idea, right? Java once was an idea in someone's brain. Unlike many other programs, its values in significant parts derives from the values who do not hold copyright, namely computer programmers, invest their own time and effort to make use of the system. And unlike many other programs, its value lies in efforts to encourage programmers to use that system so they use Sun's programs that Google did not copy. Although copyright protects many kinds of writing, we've emphasized the need to recognize that some works are closer to the core of copyright than others. This would be the fact-fantasy distinction we referred to much earlier. In our review, for reasons just described, the declarative code is, if copyrightable at all, which again we assumed for some reason, further than are most programs, such as implementing code for the core of the copyright. So they think that declarative code, wherever it is on this continuum, is more close to the fact element than implementing code. Okay, I guess. That fact diminishes the fear expressed by both dissent and the Federal Circuit that application of fair use would seriously undermine the general copyright protection Congress has provided for computer partners. And the meaning of the factor points to fair use. Okay, I'm not 100% sure I buy the distinction, personally, but it's the law now, so let's go with that. If we are saying where computer code lies on the fact-fantasy hierarchy or spectrum, right? The Supreme Court has concluded, which, is now law because Supreme Court. The Supreme Court has concluded that declarative code and implementing code are at different places on the spectrum. Implementing code is closer to fantasy, and declarative code is closer to fact. I'm not 100% sure I buy that because I would like to remind everyone that declarative code itself was, invented by someone. And, had some creative elements in there. So I'm not sure I buy that distinction, but I don't have to because it's the law now. Let's press on. The purpose and character of the use. All right, so in this context, we're trying to analyze why we're using it. This is more of, are we using it for educational purposes or more of commercial purposes? Well, one would imagine this is more on the commercial element of this spectrum. But there might be some educational stuff here. So I would score this, if I'm scoring it in my mind, more on the commercial. So let's see if the Supreme Court agrees with me. In the context of fair use, we've considered whether the copier's use adds something new with further purpose or different character, altering the copyright worth with new expression, meaning, or message. Commentators have put more broadly, asking whether the copier's use fulfills the objective of copyright law to simulate the creativity for public illumination. In answering these questions, we've used the word transformative to describe copying use that adds something new and important. And artistic painting might, for example, fall within the scope of fair use, even though it precisely replicates a copyrighted advertising logo to make a comment about consumerism. Yeah, I mean, that's totally fair, right? If you are borrowing a work, right, you can borrow a work to make a comment. So you can use a work if you're commenting, transforming the original. Of course you can. Or as we've held in Campbell, our parody can be transformative because it comments on the original, and parody needs to mimic the original. Google copied portions of Sun Java API precisely, and did so for the same reasons Sun created those portions, which seems like it counsels against, but to enable programmers to call up the implementing programs that would accomplish the task. But since virtually any unauthorized use of copyrighted computer program, say for teaching or research, would do the same, yeah, but in the teaching or research example, right, that's again distinguishing between the commercial and educational use. So that would come out differently. It would be equivalent, or at least comparable to, making copies of a portion of Harry Potter in order to sell it versus a portion of it as a classroom lecture, or something like that. It's like there's a difference there. So yeah, the purpose for which you're using it. So yeah, it would make a difference if it's educational or commercial, like it always does. To stop here would severely limit the scope of fair use. Rather than determining what's transformative, we must go further in characterizing the purpose and character. Here, Google seeks to use Sun Java API to create new products. Yeah. It seeks to expand the use and usefulness of Android phones. Its new products offers programmers a highly creative and innovative tool for a smartphone environment. To the extent Google used parts of the API to create new platforms that could be readily used by programmers, its use was consistent with the creative processes that's basic constitutional objective of copyright itself. The jury heard that Google's limited use of Sun Java API of task and specific programs demands related to Android. It copied the API, which Sun created for use in desktop and laptop computers. I don't know that really matters, to be quite honest. I mean, for me, you can disagree. But does the fact that when Java was created, it was created for desktop and laptops and not mobile phones really matter? I guess it depends the degree to which you think a mobile phone is distinguishable from a laptop or a desktop. And then you have to analyze on what level. It's like, because, it's a computer, right? How different can it possibly be? I don't know, man. My desktop computer connects to a Wi-Fi. My phone connects to a tower. What's the difference, right? I don't know. Especially in the case of Java, because as was noted earlier, one of the goals of Java was to be platform independent. So the idea was write once, use anywhere. So even though Java, when it was created in its creator's eye, was only thought of for desktops and smartphones, the entire point was to be platform independent. So how much can the fact that it's a mobile phone really matter in this, right? I don't know. It only did so insofar as it allows programmers to call on those tasks without discarding a portion of a familiar language and learning a new one. To repeat, Google through Android provided a new collection of tasks operating in a distinct and different environment. Those tasks were carried out through the use of new implementing code that Google wrote, designed to operate within the new environment. Some of the amici refer to what Google did as re-implementation, defined as building of a system that repurposes the same words and syntax of an existing system in which programmers could use the ability. Yeah, so if you buy that, right, if this is merely reusing the word and reusing the grammar of a language, that's not copyrightable. So this depends on, I suppose, how you perceive it, because the words of a language are not copyrightable. Its underlying grammar is not copyrightable. So, depends how you perceive this thing, I guess. The record here demonstrates numerous ways in which re-implementing an interface can further develop copyright of computer programs. The jury heard that shared interfaces are necessary for different programs to speak to each other. Well, not necessarily a shared interface. There can be in between, but whatever. It heard that re-implementation of interfaces is necessary if programmers are able to use their acquired skills. I don't think that's true, because programmers can learn more than one language. It also heard that reuse of APIs is common in the industry. Just because it's common doesn't mean that it's legal. It's a little bit like saying, it's a little bit like saying, and maybe this isn't fair, but it'd be a little bit like saying, well, people have been downloading things on torrents forever, so therefore it's legal because people have been doing it. It heard that Sun itself had used pre-existing interfaces in creating Java. I couldn't speak to whether or not that's true, and even if it is true, it would mean that Sun violated someone else's copyright if the analogy holds. And it heard that Sun's executives, through widespread use of Java language, including the use of smartphones, would benefit the company. But just because it would benefit the company doesn't mean that there's not a copyright interest. You can do something that would benefit Disney, and Disney can still object to it if you're violating their copyright. Amici supporting Google have summarized these same points that witnesses explained to the jury. There are two other considerations that are often taken up on the first factor: commerciality and good faith. The text of 107 includes various non-commercial uses, such as teaching and scholarship, as pragmatic examples of privileged copying. There can be no doubt in finding that copying was not commercial in nature tips the scales in favor of fair use. But the inverse is not necessarily true, as many common uses are indisputably commercial. That's true. I mean, that's definitely true these days. Just because it's commercial, although I don't think that's fair. Actually, I do disagree with the Supreme Court. I disagree with Justice Breyer. Justice Breyer says that finding it's not commercial tips the scales in favor of fair use, and the inverse is not true. I disagree. If finding the copying is not commercial tips the scales in favor of fair use, then with respect, in my view, finding that the copying is commercial should tip the scales against. So I can't see any obvious reason why concluding that non-commercial tips the scales in favor would lead to the conclusion that commercial doesn't tip in scales against. That seems a very odd conclusion to my mind. Now, that being said, note the words I'm saying very, very carefully. Tips the scales. Tips the scales. That doesn't mean the end conclusion isn't fair use. Right? I'm not saying that because it's commercial means it isn't fair use. I'm not saying that at all, because that would be dumb. All right? And I don't even think the Supreme Court is saying because it's non-commercial, that means it's fair use either. It's not dispositive. It's a factor. So yeah, the fact that it's commercial, in my view, should imply that it tips the scales. Does that mean that ultimately the scales ultimately weigh that way? Of course it doesn't. It's a factor. But I disagree with the Supreme Court. It doesn't tip the scales. I don't even understand this. This is dumb. I disagree with Justice Breyer. Justice Breyer is wrong. The Supreme Court is wrong. But apparently it's law now, so apparently the fact that it's commercial in no way implies it's not fair use. Somehow. Okay, great. Well, that's the law now, apparently. For instance, the text of 107 includes examples like news reporting, which is done for commercial profit. So even though Google's use was commercial, a fact that no one disputes, that's not dispositive. I agree it's not dispositive. To say it's dispositive is not the same thing as saying it tips the scales. Those are very different things. As for bad faith, our decision in Campbell expressed some skepticism of whether bad faith has any role in fair use. We find the skepticism justifiable, as copyright is not a privilege reserved for the well-behaved. We have no occasion to say whether good faith is a matter helpful. We simply note the strength of other factors points to fair use. Well, that is not really that satisfactory of an analysis in my view. Maybe you think it's the greatest thing ever. I don't think it's the greatest thing ever. It is not very satisfactorily written, in my humble opinion. Leave something to be desired, in my legal opinion, because, yeah. If one considers declaring code in isolation, the quantity amount that Google copied was large. Google copied declarative code for 37 packages, total amount of 11,015 lines. Those lines of code amount to virtually all the declaring code need to call up hundreds of different tasks. On the other hand, if one considers the entire set of software in the API, the quantity was small. The total set of code, including the implementing code, amounts to 2.86 million lines, of which 11,500 would be 0.4%. Okay. The question here is whether 11,500 lines of code should be viewed in isolation or as part of the whole. We've said that even a small amount of code may fall outside the scope when it's the heart of the work. Yeah, that's very true. Yeah, and that's, again, a factor that would tip. So yeah, you can, if you copy a small amount, but the small amount is the heart of the work, then you're in trouble. Right? So it makes a difference how important it is in the work. So yeah, that's a factor that definitely tips against. On the other hand, copying a large amount of material can fall within scope of fair use if it's copied, captures little of the creative expression, or is central to the valid purpose. True. A defender had copied one sentence of a novel. That copy may well be insubstantial, but that single sentence sets forth one of the world's short stories. When he awoke, the dinosaur was still there, which I didn't know was a short story. Did you know it was a short story? Apparently, this is a story. When he awoke, the dinosaur was still there. Okay, the question looks much different, as the material copied constitutes a small part of a novel, but the entire short story. Okay. Several features of Google's copying suggest that better way to look at the numbers is to take into account the several million lines. Excuse me. Several million lines that Google did not copy. For one thing, Sun Java API is inseparably bound to task implementing lines. Its purpose is to call them up. For another, Google copied the lines not because of creativity, their beauty, or any sense because of their purpose. I'm not sure that's really true either. I mean, in some sense, they did kind of copy because they're beautiful. I mean, or to put it maybe slightly different, elegant. So, It copied them because programmers already learned to work with the system, and it would have been difficult, perhaps prohibitively so, to attract programmers to build its Android operating system without them. I'm going to press X to doubt on that one. I don't know. Further, Google's basic purpose was, I mean, come on. Because the reason I press X to doubt on this is because, it's a major platform for smartphones, and it's Google, so I'm not sure that if they hadn't used this, that it would have changed much. I don't know. I mean, we're going back and trying to rewrite history, and how much difference would it make? I don't know, but I'm not sure I buy that completely. Further, Google's basic purpose was creating a different task-related system for different computing environments, such as smartphones, and to create a platform, the Android platform, that would help achieve and popularize the objective. The substantiality factor will generally weigh in factor of fair use. When it's here, the amount of copying is tethered to a valid transformative purpose. I'm not sure I agree it's transformative within the meaning of the law. I mean, I'm not trying to be a dick here. I'm really not. I'm just trying to give you my best legal analysis, which I know many of you disagree with, which I appreciate. And I think some of you also think that I'm disloyal to the cause because, I have a computer science degree and I programmed in Java way back in the day. And you're like, well, how can you possibly come to these conclusions? So, maybe I'm going to be expelled from the good of the order, which is very sad for me. But is it transformative? No, it's not transformative, in my humble opinion, because the declarative code is being used exactly for the purpose the declarative code was invented for. That's the whole point of this thing. It's distinctly not transformative. It's distinctly not transformative to use the declarative code. The entire point, and we read this earlier in the opinion, was to use these pre-existing libraries, pre-existing things, as shortcuts. It's distinctly not transformative. The shortcut still goes to the exact same place it was before. It didn't go somewhere different. We didn't use it for a different purpose. We used it for exactly the purpose for which it was designed. The same purpose for which all the implementing code was designed. In what sense is it transformative? If it's transformative, that would imply legally to me. If it's transformative, it would imply legally to me that every implementing code that calls a declarative function is somehow transforming the declarative function, even though it's the same declarative function and does literally the same thing. Does that sound like a legally tenable conclusion to you? Because it doesn't sound legally tenable to me. I know this is not necessarily the result you guys want, but I'm not here to tell you what you want. You guys know that, right? I'm here to tell you what I think, even if it's not what you want to hear. Because I'm a good lawyer and I try to do my best, even if it's unpopular, and even if it disagrees with the Supreme Court. And I admit when I'm wrong, and I admit when I disagree, and I make it plain. I'm not trying to hide the ball here. But is this transformative? In what sense is it transformative? How does it transform it? It's using it for exactly the purpose for which it was created. I'm not buying it, man. No disrespect here. We do not agree with the Federal Circuit's conclusion that Google could have achieved its Java compatibility object by copying only the 170 lines of code that are necessary to write in the Java language. In our view, that conclusion views Google's legitimate objective too narrowly. Google's basic objective was not simply to make the Java programming language usable. It was to permit programmers to make the use of their knowledge and experience. See, this is also where I disagreed. They didn't merely just copy the function calls. Right? That's what they seem to be saying, if I'm understanding it correctly. They didn't just merely like copy the function calls, which would be more analogous, in my humble opinion, to like, using the to just citing a word in the dictionary. They actually copied the underlying declarative code. They didn't just copy the function call. They actually copied what it was doing. They copied the language of it. And that, I don't know, man. In principle, Google might have created its own different system for declaring code, but the jury could have found that doing so would not have achieved the basic objective. In a sense, the declarative code was the key it needed to unlock the programmer's creative energies. No, it isn't. The programmers would have been equally creative in a different language. They're creative in many languages. What are you talking about? And need those energies to create and improve its own innovative system. We consequently believe substantiality factor will raise in fair use. The fourth statutory factor weighs upon the effect of copying in the market for or value of the copyrighted work. Consideration of this factor at least, okay, where does the market affect? That's a good question. So let me do that before I read the Supreme Court. So what is the market effect? Okay, when we're looking to market effect, we're primarily looking to whether or not the replacement is a substitution in the market. In other words, would people use this in lieu of Java? Would they use this in lieu of Java? Probably not. I mean, that seems unlikely. It's not all of Java, that's for damn sure. And it only has like these 37 libraries and 1150 codes, which I mean is something. But I mean, would you use this in lieu of Java? Would a person, because of this stuff, would you use it in lieu of Java? I don't think so. I think it's kind of neither here nor there. So I don't see a market impact. I don't see this as a substitute in the work. So I'll give Google this one. It's because I'm such a nice guy. Q Squared gives me $10. Thank you, Q Squared. In my humble opinion, as a technology professional, it should have been ruled non-copyrightable. Well, I would have been happy if they decided either way, Q Squared, to be quite honest. However, the longer this opinion goes on, the more it feels the Scottish is using the strength of right of fair use. Maybe they are. Maybe they are strengthening the right of fair use, and maybe that's a good thing. Maybe that's a good thing. Maybe it is a good thing, and maybe I'll change my mind later. Because, I mean, at least in part, my analysis is based on my understanding of the law thus far. And I suppose I could be like, well, this is a good thing because I think this is where the law is moving. I haven't gone there yet, but, But yeah, maybe it's a good thing ultimately then. Maybe strengthen fair use. Maybe it's a good thing. I think there was one other super chat I didn't give recognition to. No, not so far. So thank you, Q Squared, for the $10. It's appreciated. All right. So I don't think there's a substitution factor here. So I think this probably goes in favor of Google. The fourth factor discusses the effects of copying in the market. Consideration of this factor, at least where computer programs are at issue, can prove more complex than it first seems. It requires a court to consider the amount of money that copyright owner might lose. I'm not sure that's exactly right, but let's go with that. As pointed out in Campbell, verbatim copying of original in its entirety for commercial purposes may prove a market substitute. Making a film of the author's book may simultaneously mean potential or presumed losses for the copyright owner. Those losses normally conflict with copyright's basic objective, providing authors with exclusive rights. But loss of revenue is not the whole story. Well, that much I agree for sure. We here must consider not just the amount, but the source. That's true, whether it's a substitute or not, right? Just because you're losing money doesn't make it an infringement, right? That's not what a substitute means. No. As we point out in Campbell, a lethal parody or a scathing review might kill demand. That doesn't mean it's a substitute. This kind of harm, even if directly translated in dollars, is not cognizable. Yeah, if I do something that's fair use, right, that causes you a lot of damages, then sucks to be you. Further, we must take account in the public benefits of copying will likely produce. Are those benefits, for example, related to copyright's concern for creative production of new expression? Are they comparatively important or unimportant with compared with new dollar amounts, likely loss? We do not say these questions are always relevant to the application of fair use, not even in the world of computer programs. Nor will we say that these questions are the only questions, but we do find them relevant in helping to determine the likely market effects. As to the likely amount of loss, the jury could have found that Android did not harm the actual or potential markets, and could have found that Sun itself would not have been able to enter those markets successfully when Google did, or did not copy a part of the API. No, Sun Microsystems presumably could develop, Oracle could presumably enter the smartphone market if they were so inclined. First evidence in trial demonstrates regarding the use of Android, Sun was poorly positioned to succeed in the market. I don't know, man. I don't know if that's true, but let's go with that. The jury heard ample evidence that Java's SE primary market was laptops and desktops. Yeah, but it was also designed to be an interoperable language, so you know. As far back as 2006, prior to Android's release, Sun's executive projected declining revenue for mobile phones because of emerging smartphones. When Sun's former CEOs asked directly whether Sun's failure to build a smartphone was attributable to Google's development, he answered no. Yeah, of course not. Why would it be? Given the evidence shown that Sun was beset by business challenges in developing a mobile phone program, the jurors were entitled to agree with that assessment. Okay, let me think about whether or not I agree with that or not. I don't think I agree with that because I don't think it's asking the right question. I don't think the relevant question is whether or not Sun Microsystems or Oracle could enter the smartphone market. I think the right question is relating to the programming language, not the cell phone. That's the issue, right? Because the infringement is related to the copyright, which is related to the programming language. So saying that Sun or Oracle can enter the mobile phone market or not is not, in my opinion, asking the right question. The right question is asking, what is the market for the computer programming language on mobile phone platforms, regardless of whether Sun or Oracle themselves could themselves enter the mobile phone market as such? In other words, was Sun or Oracle... All right, let me try to phrase this properly. If Google had not used Sun or Oracle's code at all, would Sun/Oracle be in a better position to sell its code in whole or part to some mobile phone manufacturer or operating system manufacturer? So did the fact that Google copied Oracle's code, did the fact they copied it wholesale, for example, prevent Oracle from selling it to Google? Yeah. And did it interfere with their ability to sell their programming language and be a market in that domain? So I think Breyer is asking the wrong question, in my humble opinion. Let's press on. Second, the jury was repeatedly told devices using the Android platform were different in kind from those licensed by Sun Technology. For instance, witnesses explained the broader industry design between smartphones and similar feature phones. As specific devices that use Sun systems, the jury held that one of those phones lacked a touchscreen while another did not have a QWERTY keyboard. Yeah, but okay. For other mobile devices, the evidence shows that similar products like Kindle use Java software, while much more advanced technology like Kindle Fire were built on the Android system, which I'd like to take note was built at least in part on Java, which suggests Java might have some value in that domain. The record evidence demonstrates that rather than just repurposing the code from larger computers to smaller computers, Google Android platform was part of a distinct market than Java software. Is Google Android's platform a distinct / more advanced market than Java? I don't know. I don't know how to answer that question, to be quite honest. Is it a different market? Which is pretty relevant to this factor, to be quite honest. Presumably, if they're different markets, then it can't be a market substitute, can it? If they're different markets, it can't be a market substitute. So that would be pretty dispositive. So if they're different markets, it's not a market substitute. So is Java in a different market than Android? Especially at the time of creation, because I think that's important. We have to factor this into. I don't think it's fair to ask that now. I think we have to go back to the time. I think we have to go back to the time of what happened, because we have to make sure that we're not improperly incorporating the history of what has happened. We have to consider this from the position of the time in which this was happening. So at the time, were they different markets? And I don't know. The answer is yes, because at the time, I'm not so sure about the smartphone market existing as such. I mean, it was nascent. It was being created. Why wouldn't Java be in a position to compete in that nascent market? If someone said, can I modify this? I don't know. I don't know. You guys can discuss that amongst yourselves. I'm not sure how I feel about that one. Looking at these important differences, Google economics expert told the jury that Android was not a market substitute for Java. As explained, the two products are on very different devices, and Android's platform, which offers an entire mobile operating stack, is very different than the type of product of Java SE, which is just an applications programming framework. Taken together, evidence showed that Sun's mobile phone business was declining, while the market increasingly demanded another form of smartphone technology that Sun was able to offer. Finally, the jury also heard evidence that Sun foresaw a benefit from the use of Java programming language in a platform like Android, as it further expanded the network of Java-trained programmers. The very fact that Sun foresaw a benefit suggests that there's a market for it. If Sun foresaw, geez, this will be really helpful in the market because people will use it and it will help us, it suggests a market for it. In other words, the jury could have understood Android and Java SE as operating in two distinct markets. And because there are two markets at issue, programming and learning Java language to work in one market, smartphones, are then able to bring their talents into other markets, laptops, which makes you question how different the markets are in the first place. Sun presents evidence to the contrary. Indeed, because if they were truly different markets, can you think of any other example where someone could learn something from one market and it be readily applicable in a completely different market? I mean, the fact that programmers can go back and forth between these supposedly distinct markets somewhat implies they're less distinct than might appear. If a programmer can relatively easily switch between these comparatively distinct markets, how distinct can they possibly be? You know, I'm like, I don't know, man. I don't know. Sun presented evidence to the contrary. Indeed, the Federal Circuit held that market effects factor militated against fair use in part because Sun had tried to enter the market. That does suggest it to me. But those licensing negotiations concerned much more than 37 lines of code. So what? I mean, that makes that stealing less is okay. I mean, covering broad topics like the implementation of code and branding and cooperation between the firms. Okay, so it also extended to trademark issues. All right. In any event, the jury's fair use determination means neither Sun's effort to obtain a license nor Oracle's conflicting evidence can overcome evidence indicating that at a minimum it would have been difficult for Sun to enter the smartphone market even had Google not used portions of the API. On the other hand, Google's copying helped Google make a vast amount of money from the Android platform, and enforcement of the Sun API copyright might give Oracle a significant share of those funds, which, maybe. It's important, however, to consider why and how Oracle might have become entitled to this money. When a new interface like an API or a spreadsheet first comes to a market, it may attract new users because of its expressive quality, such as a better visual screen, or because of its superior function. As time passes, It may become valuable for a different reason because users, including programmers, are just used to it. They've already learned how to work with it. Which, I don't know how dispositive that is one way or another, because you could broaden that out to just technology in general. It's a little bit like saying that once technology, it would be a little bit like saying something that's patentable no longer is patentable simply because people have gotten used to it. I don't know that I buy that completely, or there's something in there that's very unsatisfying. The record here is filled with evidence that factor accounts for Google's desire to use the Sun Java API. The source of Android's profitability has much to do with third parties' investment in Sun Java. It has correspondingly less to do with Sun's investment in creating the Sun Java API. We have no reason to believe the Copyright Act seeks to protect third parties' investment in learning how to operate a creative work. That seems to counsel strongly against. That's very, very odd. Doesn't that seem to counsel very, very strongly against? We have no reason to believe the Copyright Act seeks to protect third parties, such as programmers, investment in learning how to operate a created work. That seems to counsel right against. If the Copyright Act does not protect programmers' investment in learning how to operate, then what the hell is this opinion talking about? Am I the only one reading this as directly contradicting the primary thesis? Am I the only one here? We have no reason to believe the Copyright Act seeks to protect programmers' investment in learning how to operate a created work. Isn't that the entire reason that was copied? Because of the this doesn't make any sense. Isn't the entire reason that Google copied it, according to the Supreme Court, because of the investment? And because they were invested and familiar with it, that it would be good? But copyright doesn't seek to protect that investment. It's irrelevant. What? Am I the only one who's seeing a contradiction here? Am I insane? Please let me know if I'm insane. This doesn't make sense to me. Finally, given programmers' investment in learning the Sun Java API. What? You guys got to help me. You guys got to help me. How am I missing this? You guys have got to help me. How these two sentences go back to back. Seriously, how these two sentences go back to back. I'm going to even highlight it because I have an editing tool which I can do that. Let me mark it up because we can highlight it together. Okay. So, yeah. Okay. Let's just highlight these two sentences. We're going to spend a little time trying to figure out between you and I how these two sentences operate in the same exact universe. How can we say these two things back to back? Please help me. We have no reason to believe the Copyright Act seeks to protect third parties' investment in learning how to operate a creative work. Finally, given programmers' investment in learning the Java API, okay, Kurt. Okay. We have no reason to believe the Copyright Act seeks to protect programmers' investment in learning how to operate a creative work. Given the programmer's investment in learning the created work, what the actual fuck? What the actual fuck? How do these two sentences go together? They're literally back to back. How do these two sentences exist in the same universe? My mind is blown. My mind is blown. Ugh. Okay, we'll just press on for the moment so I don't have a stroke. Given the costs and difficulties of producing alternative API with a similar appeal to programmers, what the heck are you talking about? I mean, okay. All right, wow. I mean, can we just appreciate for 1 minute here that the Supreme Court thinks it would be difficult to create a different API that has similar appeal to programmers? The Supreme Court thinks that would be difficult. Well, that would imply, in my opinion, if it is difficult to produce an alternative API that would have similar appeal to that of Java, it would imply that insert programming language X's API of the past, which at the time was popular with programmers, must necessarily be popular now. Because after all, Java isn't programming language X, right? So programming language X APIs was super duper popular at the time, super popular. And it must be really, really difficult to create something that would be just as popular, if not more popular. So Java certainly can't be more popular than programming language X, because programming language X will be popular forever, because it's popular now and it'll be popular forever. And because Java's popular now, it will also be popular forever. Nothing will ever be as popular as Java API, because it's really difficult to produce an API that will ever be as popular as Java API. Java is so great that it will be super, super difficult, to the point of impossibility, to create an API that would ever compete with Java, or will in any way be adopted by more people than Java at any point in the future, just like in the past, because programming language X in the past is still the most relevant one today. I'm going to go insane. I'm going to go crazy. It's me against the Supreme Court. I'm going to go nuts. Given the costs and difficulties of producing alternative API, allowing enforcement here would make Sun Java's API declared in code a lock limiting to future creativity of new programs. Oracle alone would hold the key. Well, this is one hell of a conclusion. Guys. If we went the other way and said, you know what, after all, the Java API is totally copyrightable, and this is totally not fair use. If we went the other way on this issue, it would mean that for all of time, that Oracle would hold the key to all future creativity of all programs going forward. Because no one could possibly create an API that would be attractive. So Oracle alone will hold the key for all of time for all programs if we rule that the Java programming language API is copyrightable and this is not fair use. No one could ever come up with such a thing, and Oracle alone will be in possession of this until the end of the world. Oracle alone would hold the key. Okay. This result could be profitable to Oracle or other firms holding copyright in computer interfaces. Those profits could well flow from creative improvements, such as perhaps a new API, new applications, and new users. Your use is developed by users that have learned to work with the interface. I'm going to have a stroke. To that extent, the Lockwood interface with not further copyright's basic objectives. After all, copyright supplies the economic incentive to both create and disseminate ideas. No, it doesn't. Oh my God. I'm sorry the U.S. Supreme Court said this in Harper v. Roe, but oh my God, no, it doesn't. This is so wrong, I cannot even begin to say it. Apparently, I've never read Harper v. Roe, because apparently I'm about to have another stroke. Because apparently the U.S. Supreme Court at some point in the past said copyright supplies the economic incentive to create and disseminate ideas. my God. Oh my holy Lord. Sweet Jesus, have mercy on me. Please have mercy on me. Okay. No. Just absolutely no. All the no. So very, very no. No on levels I cannot even begin to express. Copyright, in absolutely no respect whatsoever, provides incentive to disseminate ideas. Copyright, very specifically, very notably, very importantly, provides an incentive to disseminate expression. Expression, not ideas. Expression. It's the idea-expression dichotomy. It's only one of the most fundamental concepts in copyright law. The idea-expression dichotomy. Holy God. I'm going to have a stroke. And re-implementation of a user interface allows creative new computer code to more easily enter the market. The uncertain nature of Sun's ability to compete in Android's marketplace, the source of its lost revenue, and the risk of creative-related harms to the public when taken together convinces this four-factor mark factors also weighs in fair use. Sure, let's just agree with the Supreme Court so I don't have to think about it anymore. Let's move on. The fact that computer programs are primarily functional marks makes it difficult to apply traditional concepts in the technological world. In doing so, we do not change the nature of those concepts. I'm not so sure about that one. We do not overrule or modify our earlier cases involving fair use. Cases, for example, involve knockoff products, journalistic writings, and parodies. Rather, we've recognized the application of copyright doctrines such as fair use have long proved a cooperative effect of legislators and the courts, and Congress, in our view, intended it so continue. As such, we looked in the principles set forth in the fair use statute and set forth in our earlier cases and applied them in a different kind of copyright work. We reached the conclusion in this case where Google re-implemented a user interface, taking only what was needed to allow users to put their accrued talents, which I'd like to remind you is irrelevant because the Supreme Court itself said it was irrelevant. Remember where the Supreme Court said it was irrelevant? Because the third parties accumulated what... Taking only what was needed to allow users to put their accrued talents to work in a new and transformative program. Google's copying of the Sun Java API was fair use of that material as a matter of law. The Federal Circuit's contrary judgment is reversed, and this case is remanded. I broken. I think they broke me. I think they finally did it. I think they broke me. Okay. Wow. All right. All right. Let's. I need a second. I need a second. I need a second. I'm just gonna sit here for a second. Hold on. Just give me a second. All right. Okay. So there's a couple of things we can consider here. First of all, we can consider the result in the abstract, I suppose, whether or not we like this result in some sort of abstract sense. And to that, I suppose you guys are entitled to your own judgment. Like, we can divorce this just from the law for a minute and try to figure out whether you like this in the abstract or not. Like, we don't have to tie it to law, and just like, do you think this is a good thing or not? You know, and I would only caution slightly as you're considering this proposition that you might want to consider the proposition that you created maybe you did the impossible. Apparently, maybe you do the impossible and create a new programming language that somehow, and God forbid, is somehow as popular, if not more popular, than Java. I know such a thing as would be impossible because the Supreme Court told us, but let's just work on that premise. Let's work on the premise that somehow you create a new programming language that's more popular than Java, and you and people rip off your declarative code. I'd suggest maybe that might influence your decision to some degree. But of course, that would never happen because you can't possibly do that because it's impossible. So let's not worry about the impossibilities anymore. So we can consider that, whether we consider in the abstract. Second of all, we can consider whether or not we agree with it in the context of the current law. I have my doubts, as I've expressed throughout. I thought, if we go back and listen to my stream on this issue, I thought there were a lot of competing factors. I didn't think it was a slam dunk. I didn't think it was a slam dunk either way. I thought Oracle might have the better end of the day for reasons that I've expressed throughout the stream and in the original listening to the audio. And I know that's a bit of an unpopular opinion, but I've tried to express why using my informed perspective for whatever value it has. I mean, not to put too far, as we mentioned earlier, Google did create their own declarative code in large part. It's not like it's impossible, even though the Supreme Court seems to think it is for some reason. I'm not sure why the Supreme Court thinks it's impossible for Google to create its own declarative code when it did to a large degree, but all right. So they could have done that, and they come up with their own expression, and that would have been fine. So I'm not sure about that, and this opinion broke me on levels. So okay, I also, on a personal level, I know there was a lot of dissent around this view as well, but I was of the opinion that if Oracle won, it was not going to break the internet and programming. There were some people out there and I could have been wrong, but I'll just give you my opinion for whatever it was worth, which is still my opinion for whatever it's worth. I don't think a decision for Oracle would have broken the world. I didn't think it was that big a deal. I know some people thought it was a big deal. Some people thought, well, this means that things will have to be taken down off GitHub. This means that, PC compatible PCs would be illegal. This means calls to, the BIOS would be illegal, and blah, 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 blah. And I'm like, I'm not sure it necessarily implies those things, but, I could be wrong. So I didn't think it was that big a deal. Even though some people thought it was the end of the world, I was less convinced. I thought Oracle had a pretty good argument because, it wasn't just function calls. It was declarative code. They actually copied the underlying declarative code. They copied it. They didn't just cover the function calls. So it's like, and Google did create its own declarative code. It's not like it's that hard. And they could have created similar declarative code that would have been the similar format that people would have understood. And it's not like other people haven't created declarative code that's been relatively successful. And, so I didn't think it was that big a deal. And I still don't think it's that big a deal. I guess this is good for fair use in some way. Okay. Let's read some dissent. Oh, there's an appendix. Okay. Now we're going to read some appendix. This should be good. Let's just press on. Appendix A, Computer System Diagram. God save me. Some readers might find it helpful to start with an explanation of what a software platform is. Put simply, a software platform collects all the software tools the programmer may need to build computer programs. The Android platform, for instance, includes a operating system, core libraries, and a virtual machine, among other tools. The diagram below illustrates the general features of a standard computer system with a dotted line reflecting the division between a computer's hardware and software. It is not intended to reflect any specific technology in this case. Okay. So we, okay, that's all right, fine. Great. Appendix B, Sans Java's API diagram. Yeah. The implementing depicts the connection between three parts of the Java API issue using the district court's example. The programmer enters a method call to invoke a task from within the API. Press symbols in the method call constitutes a single task. The class is located within a package. All the lines of code that provide the organization are declaring code. For each method, declaring code is associated with a particular line. Is that implementing code that actually instructs the computer? Okay, great. Let's thumb through the dissent right now. Justice Thomas with Justice Alito. All right. Oracle spent years developing a program library that successfully attracted users, which some sites suggest creativity. Google sought a license, but when companies could not agree, they simply copied verbatim. As a result, it erased 97.5% of the values of Oracle's partnership with Amazon, making tens of $billions. Despite this majority help and fair use, the court reaches an unlikely result in part because it bypasses the antecedent question. Is software code at issue protected by copyright? The majority purports to assume without deciding that the code is protected, but its fair use analysis is wholly inconsistent with the substantial protection Congress gave to code. By skipping over the copyrightable question, the majority disregards half the analysis. Well, that much is true regardless of how you think the answer comes out. They definitely disregarded half the analysis. For sure. Properly consider the text. Code is at issue copyrightable, and Google's use is anything but fair. All right, so I'm just going to... Oracle's declarative code is central to its model. By 2005, many were racing to develop systems that would become modern sports phones. Java's platform wanted to attract programmers, but its founder, Oracle, founder of Android, understood declarative code was copyright, so Google sought a license. At least 4 times the two companies attempted to connect, negotiate, but they're unsuccessful. When they broke down, they simply used it anyway. Instead of creating its own code, as Apple and Microsoft have chosen to do, which I'd like to remind you is apparently impossible, according to the majority, even though Google also did it. Google copied the verbatim code 1,150 lines. It then advertised Android device manufacturers containing core Java libraries. Oracle's predictably responded for suit for copyright infringement. The Federal Circuit ruled it's copyrightable, and the copying code was not fair. I'm still not 100% sure I agree on the copyrightable code or not. I don't know. But assuming it is, I'm still kind of the opinion that Justice Thomas is better. Maybe Justice Thomas will convince me it's copyrightable. That would be helpful, because the majority completely ignores the issue. So we could have some thoughts on whether or not it's copyrightable or not, so that'd be great. But yeah, I mean, the court wrongly sidesteps the Constitution where it's supposed to answer. Is declarative code protected by the copyright? I hold it is. Great. Explain it to me so we can analyze that. Computer code occupies a unique space in intellectual property. Copyright law generally provides works of authorship. Patent law generally provides inventions or discoveries. A library of code straddles the two categories. It's highly functional, like an invention. Yet as a writing, it's also a word of authorship. True enough. Faced with something that can fit in either space, probably, Congress chose copyright and include declarative code in that protection. The Copyright Act expressly protects computer code. It recognizes that a computer program is protected by copyright and defines computer program as a set of statements or instructions to be used directly or indirectly in a computer in order to bring about a certain result. Which from that definition does seem like, declarative code would fall in it, at least indirectly, right? The definition clearly covers declarative codes. That's a statement that indirectly perform functions. Even without the express language, declarative code would satisfy the test for creativity. Copyrightability. Copyright protection subsists in an original work of authorship, fixed in any tangible medium. Work of authorship includes a literary work, which are works expressed in words, numbers, and verbal or numerical symbols, and a work is original if created by the author and possesses minimal degree of creativity. The lines of declarative code in the Java platform readily satisfy the extremely low threshold. Yeah, I can't disagree. It's a pretty low threshold for creativity. First, they're expressed in words, numbers, or verbal symbols, and thus are authorship. Second, as Google concedes, the lines of declarative code are original because Oracle could have created them any number of ways. That was also my point. Also in the stream, like from the oral argument, right? It's like Oracle when Oracle was creating Java, Oracle themselves could have created declarative code any number of ways. Or maybe they could have only created it this way. Or maybe they couldn't have created it at all because creating declarative code in APIs is really hard. So maybe Java doesn't exist. Maybe that's the conclusion. Because creating APIs is borderline impossible. And you could never create an API that competes with something that's currently possible. So the conclusion is Java doesn't exist. It never existed. It's all fantasy. What are we even talking about? The lines of declarative code in the Java platform readily satisfy the code. Google contends the declarative code is a method of operation, thus excluded. That subsection excludes from copyright protection any idea, procedure, process, system, method of operation, concept, principle, or discovery, regardless of form. That provision codifies the idea-expression dichotomy that copyright protections only the expression, not the idea. Oh my God. A property right in the idea itself can only be secured, if at all, by letter's patent. Thus, for example, a method of bookkeeping is not copyrightable, but the expression describing it would be. So a person who writes a book inventing the idea of declarative code has a copyright protection in the expression, but not the idea of declarative code. Google itself acknowledges that implementing code is protected by copyright, but contends that declaring code is much more functional, which doesn't really make sense somehow to me, because how? And thus is a method of operation. This argument fails. As the majority correctly recognized, declarative code and implementing code are inextricably bound together. Declarative code defines the scope of a set of implementing code and gives programmers a way to use it as a shortcut. Shortcut, I think, is kind of important in this analysis. Because declaring code incorporates implementing code, it has no function on its own. Yeah, unless you, rewrote it with the code there, and then you would, because, Implementing code is similar. Absent declaring code, developers would have to write a program from scratch, or their own declarative code, making complex programs prohibitively time-consuming. The functionality of both declaring code and implementing code will thus rise and fall together. Google's argument also cannot account for Congress' decision to define a protected computer code as a set of statements or instructions to be used directly or indirectly. That does seem kind of controlling. Congress rejected any categorical distinction between declaring and implementing. Implementing code orders a computer operation directly. Declarative does so by incorporating implementing. When faced with general language for methods of operation and specific language for declaring code, the specific governs the general. That's always true. This context makes clear the phrase method of operation in 102 does not remove protection from declarative code simply because it's functional. That interpretation does not, that has to be true. It can't be simply because it's functional, because then again, the interpretive code is also functional. It relies on other code, but it's still functional. Anyways, the interpretation, it's given more precise content than neighboring woods without association. Other terms in the same subsection, such as idea, principle, and concept, suggest method of operation covers functions, and ideas implementing by code, such as mathematical function, accounting method, or the idea of code, not the expression. Oracle cannot copyright the idea of using declarative code, but it can copyright the specific expression found in its particular libraries. Google also contends that declarative code is not copyrightable because the merger idea bars copyright protection when there's only one way to express an idea. Yeah, that argument fails because there's not only one way to express the idea. We know there's not one way to express the idea because other programming languages exist. That argument fails for the same reason the 102B argument fails. Even if the doctrine exists, which it definitely does, Google admits that it's merely an application. In any event, there may have been only one way for Google to copy the line, but there are innumerable ways for Oracle to write them. Right. Oracle could have written this any number of ways. They chose this way. The way that Oracle chose it has to be creative, right? I mean, it's got to be, right? So, I mean, okay. The court inexplicably declines to address the copyrightability. Its sole reason is that technological, economic, and business-related circumstances are rapidly changing. That, of course, is a constant. Yeah. Rather than address this question, the court simply assumes it is, and then concludes every factory use in Google, which seems strange. I agree with the majority that Congress did not shield computer programs from ordinary application of fair use. Yeah. But the majority's application of fair use is far from ordinary. By skipping copyrightability, the majority gets the methodology backwards, causing the court to sidestep a key conclusion that ineluctably affects fair use. I mean, yeah, Congress rejected categorical distinctions between declarative and implementing code. The majority creates just such a distinction. They really did. I mean, I could be wrong. Apparently, I am wrong because it's like a 4-3 decision. So, or was it 5-3? It's 5-3. I'm sorry. It was a 5-3 decision, so apparently I'm wrong. And apparently, the vast majority of my chat, when I did the oral argument react, vastly disagreed with me. And some of the chat now disagrees with me, but be that as it may, I don't know what to tell you. It's like, the Oracle could have written the declarative code a number of ways. I know that because, other programming languages do it. There's no reason that Google had to copy this code. It doesn't make sense. They wanted to copy it for convenience because people were more familiar with it. Well, whoop-de-freaking do. I mean, because no one could possibly create a format that would be even more interesting or more appealing that people would want to learn even more. This is the end all be for more formats. Impossible to create something that would be better. What bullshit is this? Justice Thomas is making a lot more sense to me, man. I don't know. By skipping majority creates this distinction. The role of distorting analysis and opinion makes it difficult to imagine any circumstance in which declaring code would remain copyrightable. That is true. I think. Yeah. I mean, that's a very good question. Would anything change? Is it possible in the majority's view for use of declarative code to not be fair use? Is that a possibility? And I'm not sure it is in the majority's view. I mean, I could reread it. I probably will at some point, but the majority's view of fair use when it comes to declarative use, it seems borderline categorical. Because it's declarative use, it's fair use, almost implicitly. I mean, what could possibly change the analysis? If it was a lot more declarative code, does that change because it's more declarative code? How? Versus less? I mean, yeah, I think Justice Thomas probably has the better end of it. The majority says declarative code is copyrightable, but fair use applies. But when you have a fair use defense, normally there would be such a concept as not fair use. Right? Like, that's possible. But if you read the majority's actual rationales, how is it possible for not fair use in the case of declarative code? And then what's left of copyright? Because the majority assumed it's copyrightable. But in what sense? If everything's fair use, what's left? So, I mean, yeah. I agree with the majority that under our precedent, fair use is a mixed question of law and fact, and questions of law predominate. Because a jury finding favor use, we must construe all facts in that favor. But whether it's fair use or one not is a legal question. Congress has established the weights, 4 factors. 3 decisively favor Oracle. And even assuming the remaining factor favors Gorgo, the factor without more cannot legally establish fair use. Yeah, Q squared gives me $5. It says, I agree the way they worded it. If it's copyright, it's implicitly fair use, which in this case means code shouldn't be copyrightable in the first place. The majority opinion is riddled with inconsistencies and illogical elements. It's not logically tenable on its own terms. It has contradictions and it just it runs into The majority holds otherwise, concluding every factor favors Gorgo and relying in large part on the distinction between declarative and implementing. Tellingly, the majority evaluates the factors in neither sequential order nor order of importance. Instead, it starts with the second factor, the nature of the work. It proceeds in this manner in order to create a distinction between the code that renders the former less worthy. Because the majority's mistaken analysis relies so heavily, I'll begin with it as well. The nature of copyright work. The factor requires courts to assess the level of creativity or functionality, and generally favors fair use when copyrighted work is more informational or functional than creative. Or to put it differently, as I said it, factual versus creative. Because code is predominantly functional, this factor will often favor copying when the original work is computer code. Because Congress determined that declaring and implementing code are copyrightable, this factor alone cannot support finding fair use. Right. Because of the nature of computer code as such, and because the law specifically recognizes computer code, it necessarily changes how this analysis must function. That makes sense. Majority, however, uses this factor to distinguish between declarative and implementing code. The effect removes copyright from declarative. It does seem that way. It concludes that unlike implementing code, declarative code is far from the core of copyright because it becomes valuable only when third parties value it, and because it's inherently bound together with uncopyrightable ideas. Congress, however, rejected this sort of categorical distinction. The copyright protects code that operates in a computer in order to bring about a certain result both directly and indirectly. And if anything, declarative code is closer to the core of copyright. Developers cannot even see the implementing code. Implementing code thus conveys no expression to developers. Declarative code, in contrast, is user-facing. It must be designed and organized in a way that's intuitive and understandable. I mean, once it's compiled, I guess it's kind of true. Even saying these concerns aside, the majority distinction is untenable. Declarative code is inherently bound together with uncopyrightable ideas. Is anything not? Books are inherently bound with uncopyrightable ideas. The use of chapters, plot, including dialogue or footnotes, notes, or what we might call scene affair sometimes. This does not place books far from the core of copyright. In implementing code, which the majority concedes is copyrightable, is inherently bound up with divisions of computing tasks that cannot be copyrighted. We have not discounted a work of authorship simply because it's associated with non-copyrightable ideas. While ideas cannot be copyrighted, expressions can be. Yeah. Simply, it makes no difference of the value of declarative code depends on how much time third parties invested in it. Many other copyrighted works depend on the same. A Broadway musical script needs actors and singers to invest time in learning and rehearsing it. But a theater cannot sell a script, the rights to which are held by a small theater, simply because it wants to entice actors to switch theaters and because copying a script is more efficient than requiring actors to learn a new one. I mean, truth there. There's some truth. Now, the degree to which you think declarative code is comparable to a script in a play, I suppose, is open to interpretation. But there's something there that's true. While the majority says declarative code is no less true of implementing code, declarative code is how a programmer accesses pre-written implementing code. Yeah, that's basically true. Declarative code is pre-written implementing code. That's kind of true. The value of that implementing code is thus proportional to how much programmers value the declarative code. The majority correctly recognized declarative code is inexorably bound up, but overlooks the importance of its own conclusion. After only overlooking concluding that the nature of code makes it generally unworthy of protection, does it move on? This taints the entire analysis. Yeah, I mean, yeah, this is... Google eliminated the reason manufacturers wanted to pay to install Java. When Oracle earned revenue by charging device manufacturers to install Java, Google obtained revenue primarily through ad sales. Majority writes up this harm by saying the jury could have found blah, 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 whatever. Unable to seriously dispute Google's actions had effect on the market, majority changes course and asserts its forcing copyright protections could harm the public by giving Oracle the power to limit creativity. But this case only concerns versions of Android released through November 2014. Google has released 6 major versions than then. Only about 7.7% of active users still run the versions at issue. The majority is concerned about a lock-in effect might carry more weight if this concern was still widely used. It makes little sense about versions that are closed ups. The majority's concern about lock-in effect is also speculation belied by history. No, it's not. The concern that Oracle will control all programs forever is not in any way belied by history, because the first thing that was ever popular is still the thing that's popular now. First, Oracle never had a lock-in power. The majority, again, overlooks that Apple and Microsoft created mobile operating systems without Oracle. Second, Oracle also made its declarative code freely available to programmers. There's little reason to suspect Oracle might harm programmers by stopping now. And third, the majority simply assumes that the jury in future suits would give Oracle control of Android instead of just awarding damages or perpetual royalties. If the majority is going to speculate about what Oracle might do, it might at least consider what Google has done. The majority expresses concern that Oracle might abuse its copyright protection and attempt to monopolize the market, but it's Google that recently was fined $5 billion for abusing Android to violate antitrust. Google controls most widely used operating system, and if companies may now freely copy libraries of declarative code whenever it's more convenient than writing their own, others will be likely to hesitate to spend resources Oracle did to create intuitive, well-organized libraries that attract programmers. If the majority is worried about monopolization, ought to consider whether Google is a greater threat. You know, I feel like Thomas over here is spitting some truth. Thomas may be old, but I feel like he's spitting some truth, man. Spitting some truth, man. By copying Oracle's work, Google disseminated Oracle's market and created a mobile operating system now in 2.5 billion devices, carrying tens of billions of dollars. If these effects on Oracle's potential market favor Google, something's wrong with our... you know. I'm... The majority acknowledges that Google used the copied declarative code for the same reason Oracle did, which is distinctly not transformational. So, by turn, the majority transforms the definition of transformative. That's what I said. If they use it for the same reason Oracle did, how's it transformative? Now we're told transformative simply means, at least for computer code, a use that will help create new products. Yeah. This new definition eviscerates copyright. A movie studio that converts a book into a film without permission not only creates a new product, the film, but also enables others to create products, film reviews, merchandise, YouTube highlights reels, and the like. Nearly every computer program once copied can be used to create new products. Surely the majority would not say an author can pirate the next version of Microsoft Word simply because he can use it to create new manuscripts. There's something true there, guys. There's something true. The majority wrongly conflates transformative use with derivative use. To be transformative, a work must do something fundamentally different from the original. It has to transform it. A work that simply serves the same purpose in a new context is derivative, not transformative. That is so freaking true. I cannot even begin to emphasize how true it is. So we're going to make sure that we all get this down, because Justice Thomas is super right. Yeah. To be transformative, a work must do something fundamentally different than the original. A work that simply serves the same purpose in a new context is derivative, not transformative. That is super, super true. It's all the true. But because, I mean, the majority themselves said this. They said they were using it for the same purpose. And I said, how's that transformative? And Thomas is saying, how's that transformative? Me and Thomas are equally confused. This doesn't make any goddamn sense. Even if Google's use was transformative, the majority is wrong to conclude that Google copied only a small portion of the work. The majority points out that 11,500 lines of declarative code, enough to fill about 600 pages in the appendix, were just a fraction of the code in the Java platform. But the proper denominator is declarative code, not all code. A copied work is quantitatively substantial if it serves a market substitute. Yeah, you know, that's actually, I didn't quite think about this, and I'm not sure Justice Thomas is quite getting there, but there is another contradiction in the majority's opinion, right? Because the majority opinion is making some pains, and I think we can all agree as to this, is making some pains as to separate declarative code from implementing code, right? We can all agree as to this much, right? The majority is very deliberately, very intentionally separating declarative code from implementing code, right? And then the majority turns right around and says, well, they copied 11,500 lines of 2.4 million, which is 0.4% of the code. But that's all the code. All the code, and declarative and implementing. You can't simultaneously say that declarative code and implementing code are different things and say, well, the 11,500 lines of declarative code isn't that much because it's only 0.4% when considered in the context of not declarative code, but all the code, which we're suddenly going to put together, even though we've been making pains to separate them. But now we're going to treat them as the same, even though we've been treating them separately. The contradictions in the majority opinion are breaking my brain. They are breaking my brain on levels that I cannot begin to understand. You can agree with the conclusion or disagree with the conclusion. You can even agree with the majority. I hope you can understand my confusion, because this to me doesn't make any sense. How can you say, well, 11,500 is only 0.4% of all the code, and say declarative code and implementing code are super, super different? Anyone got anything on that? Anyone figure out how you can do both those things at the same time? I got nothing. It does make sense. A copied work is quantitatively substantial if it could serve a market substitute. The declarative code is what attracts programmers. Apparently, because that's the majority's conclusion, remind you. That's the majority's conclusion. The majority's conclusion is the declarative code is what attracted them, because that's the super best thing. That's what people like. They like that declarative code life. It's all about the declarative code. So apparently that's what attracted programmers. So, that's what would be a substitute for licensing. And Google's copying was both quantitatively and qualitatively substantial when considered in the context of declarative code rather than all the code, which, as we pointed out, was the entire point. And it's separate, but it's the same, and it's together, and third-party investment's important, but it's not, and stroke. Angel says it's a biased opinion. I'm not sure whose opinion you think is biased. Mine, Thomas's, or the majority's. I'm not sure whose opinion you think is biased, and if it's mine, I'm not sure what you think it's biased by. But it's not, I'm not sure how my opinion is any less biased than anyone else's opinion, This is, You guys want to talk about something else for a while? Lord Costaquill says he enjoys Thomas's writing even when he's wrong. So Lord Costaquill over here is not buying the Thomas analysis, even though I am. Q Squared says, yeah, this is a good point. Again, I feel they started out finding code not copyrightable, then said, oops, we need to say that, but using fair use. Something here, man. Yeah, I not. Yeah. Michael says this isn't bias, it's nonsensical. Again, I'm not sure who you're referring to if you think I'm nonsensical. I've tried to explain my views as best as possible for all the insanity they might have, but I don't know what more to say. If you don't think it's sensical, then so be it. I've tried to express my views and tried to highlight exactly why I disagree and exactly where this is breaking down, and tried to present my own analysis and own reasoning side by side. Tried to do this as best I can. If you still think I'm nonsensical, I don't know what to do, man, you know? Yeah. Should we? I need some bourbon. And I need a big ass drink. I need a big ass drink. Talk amongst yourselves. I'm gonna get a bottle and we can talk for a couple minutes while I have a nightcap. I'll be right back. Oh Lord. Let's have a nightcap. Let's have a nightcap. We're gonna have our Texas Pecan brown sugar bourbon because, you know, I feel like, you know, something a little sweet is what we need for today. Now, let's see. We have 3 marks on this glass. Good day, bad day, or don't even ask. You know. I'll go with bad day. We should have a poll. We should have a poll to see where everyone's sitting. Let's have a poll for 75 of you here. See where you guys are sitting on this. Now, how should we do this? I guess there's really 4 options. I think majority makes sense, and I agree as to the result. I don't think the majority makes sense, and I agree as to the result. So what would be, I think the majority makes sense, and I disagree as to the result. I guess I think the majority doesn't make sense. And I agree. The result, and I don't. Oh, wait, I think it doesn't make sense, and I agree. Let's see. I think the majority. I don't think the majority makes sense. I agree. I think the majority doesn't make sense, and I don't agree to the result. Doesn't make sense. I agree. Makes sense. Doesn't make sense. I agree. Doesn't make sense. I agree. I can't even figure out how to form a poll right now. I'm so tired. My brain has stopped working. I'm sorry, no poll because my brain has literally stopped working. I can't even formulate a poll right now. My brain has totally stopped working. Well, I hope you liked the stream anyways and enjoyed watching me going completely crazy. I think it's time to sign off because nothing productive is getting done. Maybe it'll all make sense in the morning. If you are enjoying this stream, if you be so kind as to give it a like. If you're not subscribed already, why not subscribe? You can help to make the channel grow. And did you know, for 99 cents too, you can become a supporter of the channel. It's true. You can help us financially and stuff. And, that'd be great. Until later, my friends, I hope all's well. I'm a very broken Uncivil Law. And until later, cheers and goodbye.